Sorry. Lordship, may I be permitted to mention one application for its inclusion?
New application.
Lordship.
New application.
New application in connection with one Mandam.
Yes.
Good.
Your Lordship, I'm mentioning this matter for the second time. It was last mentioned on 26 June. Your Lordships had allowed my mentioning, but thereafter the matter has not appeared in the list. This is an original side, Your Lordship, writ appeal, Your Lordship. Your Lordship, the Port Trust, Your Lordship, the difficulty is the Port Trust has put a padlock at my factory, and Your Lordship, my MSME enterprise has come to a halt, Your Lordship. There are pending railway orders which I'm
mentioning upon notice.
Your Lordship, I'm mentioning upon notice, Your Lordship. Any day this week, Your Lordship, as per the convenience of Your Lordship.
My lord, kindly grant me leave to file an appeal without the certified copy, my lord.
When was the order passed?
My lord, last Friday, 4th July.
Have you applied for certified copy?
Yes, my lord, I have appeared for certified
What
copy.
is the urgency?
My lord, the tender, I am a person, I am a company who, my lord, I filed a writ petition.
It's a tender matter.
Yes, my lord. My lord, the tender closes today, my lord.
Tender would close today.
Yes, my lord. My lord, the tender will close today, but they will open the bidding from tomorrow, my lord. So kindly grant me leave to file a stay application and along with it an appeal, my lord. Because if the bidding starts from tomorrow.
Yes.
May I be permitted to mention?
Sir,
may I have the kind leave of your lordships to file the appeal without certified copy, lordship? Same.
Why? When was the order passed?
Order passed long back, 12 March, lordship.
Get the certified copy and file, sir. Yes, call the list. Yes.
Sir, I have filed an appeal against a writ order dated.
Your advocate.
Sir, in person, I am moving all my cases. Sir, please allow me to.
You're appearing in person.
Yes.
But you have filed an appeal.
Yes, sir. MAT number 936 of 2025. This appeal is filed against the order of a writ against an order dated 7th of May 2025. Sir, I'm needing some treatment papers from insurance company and the hospitals, and they are not giving that papers. And sir, already a medical negligence case has been filed in National Commission. So I am in urgent need of those documents, sir. That is the reason I filed this appeal, sir, to retrieve the treatment papers from the concerned hospitals and.
Filed it.
Yes, sir. Already filed.
Have you given notice to your
Yes, sir. Yes, sir. Everything is done, sir.
Hand over the slip.
Yes, sir. Within 5 minutes, I'll write and submit the papers. Thank you, sir. Thank you.
Your lordship, may I be permitted to mention a matter for inclusion in the list, your lordship?
Appeal or application?
Appeal, your lordship.
Appeal.
MAT.
Which year appeal?
2023, your lordship. And there's an interim order that is there, but the other side is enjoying, your lordship, and they are not appearing.
The respondent.
I am for the respondent.
Where is your notice?
So
that you will mention
email
today.
Notice. Email. It's an email to them that we are mentioning the matter. This is the
No, they give a notice to the advocate concerned and come.
We have emailed to the advocate concerned only.
When did you email?
Yesterday, lordship.
Give a fresh notice and come, because you are the respondent. You are not the appellant here. If they have not filed any opposition, it is for you to take appropriate steps. Was there any direction for affidavits?
The direction was they were supposed to carry out an amendment for adding the party that they have given the loan account for, but they have not come up with the amendment yet. And the direction for the amendment was passed back in January, your lordship.
Give a notice to the advocate concerned and come back. Then come and mention on Thursday.
One application, lordship, I am paying for non-prosecution, lordship. This.
Give this.
It.
Yes, call the list.
Item number 1. My lord, so many papers, paper books, so I will take 5 minutes time. Does it really require?
Where is the paper book?
But I'm told, my lord, it has been filed.
When did you file it?
I've got just now.
ফাইল করেছো বলো?
তা নিয়ে নিতে পারবে কি?
কপি পাইনি আমি সেটা।
Copy দিয়ে দিচ্ছি।
কবে ফাইল করেছো কবে বলো জজের কাছে? ফাইলে নেই। My lord, I have been, my lord, favored with a copy. My lord, my learned senior friend, my lord, has been served
Today
up
I've
the
got
copy.
You have filed it?
Yes, my lord, my learned advocate on record has filed.
I submitted, I'll paper. They said, no, we'll paper it. I'll do that. Do that.
Do you have extra copy?
Yes, yes, my lord, we have.
And by WhatsApp, my lord, it was sent. I do not know how it is. Such
Hard
huge
copy
number.
দেয়নি, sir?
আর সেটা এখন আজকে আমি পেলাম।
ও, আচ্ছা।
ঠিক আছে, doesn't matter. I'll take 10 minutes time. That's all.
আপনার আগে জেনে রাখুন, জেনে বলবেন ওনাকে
এটাই
কপি
তো
দাও।
ভাই কোনটে তা তো বলতে পারো না, ওরা জানে।
আমি দিয়ে দিলাম। হ্যাঁ।
না না, কোর্টের কপি কিনে জিজ্ঞেস করছে। দেখি আমার দাও এগিয়ে দাও, এগিয়ে দাও।
Yes, Mr.
Now, my lord, I'll just draw your lordship kind attention regarding the writ petitions. I'll not take much time. Kindly see what is the foundation of his case. He purchased the land, let him purchase, I don't mind. He recorded his name, let him record his name. Subsequently applied for sanctioning the plan. And he obtained the plan. He wanted to construct this as per sanction plan. But since there is a disturbance, he approached the police. Due to police inaction, there's the usual things, my lord, which is now being flooded with the cases regarding that. So he approached the writ court. And let us first see what is his foundation of his case. Kindly see, I'll not read the entire petitions, only some paragraphs. Kindly take trouble to come. Page paragraph 8, page 12 of the paper book. It's the same paper book, my lord, then there will be no problem. Page 12, para 8. Last two line.
Yes.
Paragraph 8, last two lines, my lord. The private respondent, along with his main and agents, I don't know who are they, since they are not the parties, creating hindrance in the way of legal construction of the petitioner. What he wanted to mean by the legal construction, according to my understanding, my lord, I've got a sanction plan. So naturally, whatever I'll do, that is legal. There's no doubt about it. I admit. Since he has got a sanction plan, he can say like this. Then I'll come to page 13. Paragraph 9, last three line. Page 13, para 9.
Yes.
Last three line. The petitioner has every right. Have you got it, my lord? The petitioner has every right to make construction over the said plot of land as per sanction plan of the competent authority. Of course, he has every right. He has every right to make a construction. Then kindly take trouble to come. Page 15, para 17. Short paragraph. Page 15, para 17.
Yes.
Your petitioner further submitted several outsiders who are moving around the property of the petitioner of creating illegal activities and disturbance in the legal construction of the petitioner. So every time he emphasizes on that, construction is legal because he has got a sanction plan. But ends there. Then, And his peer also like this.
Mr. Banerjee, where he has said that he has a sanction plan, have you given details?
That is the
of it?
foundation of his case.
No,
Yes, yes.
Has he given the date of such sanction or anything?
Because he got the sanction plan.
Yes, 8th of June, para 6.
বসে পড়ো নয় সরে যাও
Got it. So, my lord, this is very vital. I could have understood that well. And peer, and very, my lord, I cannot blame the learned judge. He is not at fault. Then why have challenge? Kindly see the order of the learned judge, which is under challenge.
পেজ
Page কত রে? আমি তো এই মাত্র পেপারও পেলাম।
আচ্ছা আচ্ছা স্যার 56
Page 56. Page 56. আমি জানি চুপ করো দয়া করে। Average got on affidavit of service so filed by the petitioner be kept to the record since the sanction plan has been granted by the concerned Gram Panchayat. Kalimarked it, my lord. Police authorities would ensure that no obstruction be created while raising the construction at behest of the petitioner. In case in untoward incident, there are consequential part, my lord. Naturally, court cannot silence spectator, my lord. If it is found that, well, illegal activities going on, certainly court can take proper step. So, foundation of the case, sanction plan, and order based on that. And for the state, Ansar Mondal appear, but who appeared for the concerned corporation, municipality, I do not know. And they'll give the answer to that. So this is the order, nothing more, nothing less. Very rightly, court did not enter into the merit or did not invite anything. Very well. If you have got a legal sanction, do it. And I'll direct the police to petitions. But that is the crux of this case. Now the question is this, my lord. If it is ultimately cancelled, but I was not even aware that there was cancelled. I am seriously affected. False statement stating so, because I am not a party there. I filed an application to grant me the leave so that I can pay for an appeal. My lord was kind enough to grant the permission to pay for an appeal. Appeal is now to the lawsuit. Everything is infructuous because the plan has been recalled. Suppress- I am not the person to justify or say anything. Concerned authorities there, they must answer why it was done. It is recalled. So no more. The law, this order has lost its force. My appeal has gone, lost its force. Everything is gone. I could have understood for other reasons. Whole case, foundation of the case based on the sanction plan. Rightly, wrongly, that is cancelled. If it is challenged, then naturally it is for them to justify whatever you have done, rightly done. At the present moment. That's why very fairly my friend, whom I like very much, sorry, he considered I can make the construction or plan has been cancelled. Have you challenged that? Go and challenge. So I need not proceed any further with the appeal, nor the order stand any further.
So your contention is if the plan is sanctioned now, they can raise construction as per plan.
If the plan is, if they recall, then they cannot. If the plan is there, they can do that. No, provided.
If it is, suppose you are saying that the plan which on the basis of which they moved the writ court and obtained the order, that plan is no longer there.
No longer there.
So the entire matter goes.
Goes. My appeal goes, his read goes.
So
Of course, his read is.
are we to understand this that if he obtains a sanction plan, he can raise the construction?
Once he will take the sanction plan, then that is his responsibility.
So at that, if that happens, you will not stand in the way.
I cannot. I should. If that prejudice my interest, because my partisan suit is pending, status quo is there, no more constructions. So all this is there. My lord, Supreme Court now very rightly decided on judgment that I had a privilege to appear in the High Court. There is a contempt at the point of the two neighbors, they are fighting each other regarding sanctions and others. So why your court is burdened with all this civil dispute? Supreme Court said, no, this is a civil dispute, go and file a suit. I file a suit. Suit is pending. He filed a suit, that is dismissed. Again, another suit is filed by another co-sharer, that is pending. He suppressed so many things. Unfortunately, I was not a party. I didn't get the opportunity to argue all these points. But at the present moment, what remains? Nothing. Fait accomplished.
You are not a party to the writ petition?
No. So what remains? Nothing. And very fairly he said, why not plan has been cancelled, how can I make construction? So there is no existence of any case.
Now, who are you, Mr. Banerjee?
Huh?
Yes.
You are Champahati Junior Staff Club.
It's a registered club, my lord.
Champahati Junior Staff Club was not a
Party.
party.
No. And my lord, so far we are concerned, not only we are registered, we purchase by deed. Registered deed, we purchase the property. Well, all those things I cannot disturb your lordship because civil dispute. Let me decide there. The party can raise this point. I will lose, I may win. At the present moment, nothing is left. My appeal will also go. On what basis I'll proceed? Because plan has been cancelled. Maybe bad, maybe good. It is for them to challenge or not to challenge. If it is ultimately found by the writ court, it is illegally cancelled, then my lord, again it will be revived. They'll face cause of action and other things. At the present moment, nothing is left. My appeal is gone. His order is gone. Everything is gone. He cannot expect anything. Either my client or his client cannot expect anything.
So can we record this that if he ultimately obtains a sanction plan on the concerned land, there will be no objection from your side?
No, my lord, at this stage, lordship cannot record that. There is some sort of problem.
Why?
I do not know what will happen ultimately if it is a violations. If I have a cause of action, so far I am concerned.
Your portion, you have also constructed a,
My lord, that is a different part, not there.
your argument which we understood on the first date was that a partition suit is pending.
That is pending.
In the partition suit, your prayer is that unless you partition, you cannot raise construction.
Right.
This was your condition.
Probably, my lord, I am sure.
No, that was your condition. Then
Naturally.
how you have constructed on that
So,
portion?
my lord, whatever construction has been made, that is not here. From the
That is
bar,
not-
from the
that-
bar, he made a statement that there is a construction.
Not from the bar. A written instruction was furnished by the Gram Panchayat. Very
My lord,
there-
that is not the construction of recent. Long back, when it was done, we do not know.
No, 24. Kindly take up the written-
24, nothing is constructed.
20.
Wrong.
Kindly come to that communication, Mr. Banerjee.
My lord, at which page I do not know, my lord.
That is the booklet which has been given by the Panchayat.
384. How can I say, my lord, at this stage that, well, if it is legal, 384. This is restaurant number 8. The 384, as I'm, thanks to my friend, my lord, he has helped me. My lord is referring 384. I like him very much. He never made any false statement before the court.
No, this is not the. We have been handed over.
By a communication of 14 January 2025 on the last day. 14 January.
226. That is 226.
226.
14 January is 226.
The page
There was
number.
a bunch of documents, Mr. Van. 14 January, my lord, is, my lord, the instruction which was submitted in the form of a report. That is, my lord, page 226 with all the documents annexed there.
Now, where is the letter of 2nd December 2020?
I'm really sorry, my lord. I cannot assist your lordship properly because just now I've got space.
2nd December letter, my lord, kindly allow me a moment's time.
My lord, whatever I have done, it is for them to challenge. Let them challenge. I cannot stop them. But here they cannot raise all this plea. I have committed a wrong. That's why he is also my lord.
230. 230.
230. 230.
So this is the club's communication to the
Junior staff. Kera. Oh. No, this is actually representation to the Pradhan for cancellation.
yes,
Yes.
wherein you have admitted that you have made construction
Yes.
amicably.
Well,
So,
even if it,
unpartitioned property cannot be, you cannot take it as a ground now
no,
because you
very well.
yourself-
Now everything goes, my lord. The partition, unpartitions, his plan has been cancelled. Now, my lord, I cannot invite your lordship to enter to the merit at this stage. All right, it is gone. I cannot because I could have whatever my givens is there, it is gone into wind. Because the basis of his case is I have got a sanction plan, I have constructing, I have did that. Court says very honestly, court says very well, if you got a legal sanction plan, do that. Very nicely said, nothing wrong in it. But subsequently the plan is cancelled for suppression of material facts and fraud. Then my lord, let them challenge that. So lease which is pending at the present moment, we can realize that lease is pending, whether there's even legal or illegal, that is also cannot be, I cannot say anything. I cannot, because that will may prejudice his interest. But the fact only Pradhan can say, from whom he has got the plan. If he can say that, well, the way it has been sanctioned, fraud, substance, material facts, it is really between him and the Pradhan. I'm not concerned with that. But what is fallen by lordship, Mr. Manager, today, if we pass an order that if you have subsequently obtained legal plan, you have an objection. How can I say like this at this stage, my lord? Kindly do not pass such an order. Let it be kept open. If he has got a right is always there. Here, my lord, he has misused his right.
then Mr. Banerjee, nobody can raise any construction in his own land. You being a club, you are taking a stand that it's an unpartitioned property. That is in fact what you have stated before the concert. If you claim to be an unpartitioned property, then question automatically arises that
Of course.
how you have raised
Of
construction.
course, but that is not the lease here. But let them
No.
let them file a complaint to the Pradhan
No,
that
why
how they
we
can make a construction.
shall call from you whether there is any sanction plan in respect of your structure.
No, my lord, that is beyond the scope. I can do that, but beyond the scope.
We are
Because
in judicial review. You
no, my
have
lord,
taken a
judicial
ground.
review, my lord, kindly appreciate one aspect.
No, we are not saying that you will not, we are not saying that now go and construct. You are absolutely right. Unless the sanction plan which is cancelled
Yes.
is again revived, question of issuance of this order does not arise.
Now, question, sorry.
But Mr. Banerjee, your contention in the opposition in your leave to appeal is that it is an unpartitioned property.
Well, there is a civil dispute which is pending.
Then if it is a civil dispute
Pending.
of an unpartitioned property, how you have raised construction on that?
Very correctly, my lord says. Very correctly, my
Then
lord
we
says.
call upon you to produce all the documents.
No, my lord,
of that.
very rightly, my lord says, my lord. But lease which is pending
A
before the
particular club cannot say, I will not allow you to raise a construction, though I will enjoy my
he can make,
construction on the
sorry,
own.
he can make.
That is why on the first occasion we said that you please sit and settle. Because your contention in the representations was that yes, it is an unpartitioned property, but we have entered into an amicable solution and we have allowed others to raise construction and we have also raised a construction. But now there is no amicability in respect of the petitioner. You will be thrown out. So, Mr. Banerjee, you file before us your sanction plan as regards your construction.
No, my lord.
How
Oh,
you
sorry.
have raised that? We will order demolition of everybody.
Now, if your lordship open this, my lord, then it will end the argument.
We have not
Section
opened.
14. Section
No,
14 will automatically come.
No, Mr. Banerjee, please answer our
And then, yes, I'm answering, my lord.
we have not opened. We are on your ground of challenge.
Kindly appreciate one aspect. First thing, my lord, What is the lease here?
We will dismiss the writ petition.
After that, my lord, if it is not a part of this case,
But we will mention
yes,
that if you cannot oppose such obtaining of fresh plan on a purported ground that you are building on an unpartitioned property.
my lord, one thing is very
We will
clear.
record
I
that.
cannot oppose at this stage because until this plan is sanctioned, how do I know what will happen? I cannot oppose.
Mr.
It
Banerjee,
is
I
between
think we are-
Pradhan
I
yeah,
think subject to what he says and what the Pradhan says, we are trying to appreciate. Today, I have purchased a particular plot of land.
yes,
I have a sale deed. If you are agreed by the sale deed, you can challenge my sale deed.
that's true.
So you have not challenged my sale
No.
deed. You have not challenged my. You admit me to be a co-sharer.
Yes, yes.
So if it is an unpartitioned property of
I've
co-share,
followed.
then how the club has raised the
I
bill?
have followed, my lord. I have followed. My answer is this, my lord. Subject to lordships accepted and corrections. Yes. What the point is raised by your lordships?
No, this is a specific
No, no,
admission
no.
on your part.
Based on that, whatever has been coming from your lordships is a legal aspect. How can I say no? What your my lord saying is not correct. But
No,
what,
no, that is why we are
What-
asking you how you have raised.
No,
Show us the
no, but
case.
what I'm on, my lord, what I'm on, that well, two aspects. It is a case. Suppose if I do not pay for an appeal, I'm just giving. I do not pay for an appeal. Corporations or the concerned municipality or panchayat, if we cancel the plan, all those questions cannot arise. I just simply I'm withdrawing the appeal, and because the case has lost its force in view of the subsequent event, plan is recalled, based on which he obtained an order. Then what is the position? I don't want to press my appeal because fate
You
accomplished.
have allowed your application for leave to appeal
Yes,
on the reason because you pointed out there are partition suit pending.
no, not a point, not a point. That order is passed, and I was not given opportunity of hearing.
You are
That is
not
why
made a party to it.
I was not a party.
Exactly.
That's why it is allowed.
That's
Now,
why-
my contention is very clear. Whatever is followed also a legal aspect, I cannot deny. That's on my part is a stupidity because I cannot controvert all these things. But the case is this, my lord. Suppose today, if I withdraw my appeal, and I can withdraw, my lord. I can withdraw. I am not benefited out of that,
And also, he will not be able to succeed.
my lord.
There is no plan.
No plan. So that's it.
Even you withdraw the appeal.
Then my lord, question is whether my lord take trouble to proceed further because case is finished. Case is finished. Had it been a case? No. Had it been a case? I am enjoying something.
This is a never-ending problem. Then every day, what will happen? A person will come to the writ court saying, "I am not being allowed to construct." Why? Because the village people are not allowing me to do so. What is the plea? Village people says this is an unpartitioned property. Very good. If that is your contention, we will ask the authorities to take steps against you also. How you have constructed on an unpartitioned
My lord,
property.
what point?
No, this is on record. Mr. Banerjee,
How can
kindly
you
come to-
lordships? How can you lordships
Page
enlarge the
230.
scope?
No, 230. If you have come within the scope.
No. I just pointed out this is happened.
Page 230, Mr. Banerjee.
Yes, I'm on this page.
Please read the second paragraph.
Yes, we beg to state. We beg to state that most respectfully that I am the secretary of the Champati University.
First paragraph. Read reference.
An application for cancellation of the sanction plan of the opposite parties, which has been obtained by the opposite party over a disputed and revocated land, in
Yes.
which a title suit, kindly marked it, my lord, in which a title suit being commercial charge was dismissed by the learned civil judge. It is this suit. Then, first called Baraipur, Champati Junior High School, Government High School, Mondal, Resident Village. We beg to state most respectfully that I am the secretary of the Champati Junior. So we are organizing various social activities constructed and since long, and we have constructed our Pakka Club Ghor and Durga Moncho and small playground in our purchased land situated Muja such and such is situated as per possession of our previous owner, and we are possessing the same. Kali marked it one thing, my lord. Total area of the land 28 Sotok. Entire thing is jumbled up, confusing there. 28 Sotok. Some portion which was sold earlier, and there is a actually exclusive possession of my client.
Where do we find it?
We purchase.
Exclusive possession, if it was exclusive possession, how on amicable solution you have raised
So
it?
that they may not face any PS club.
They cannot raise. If it is a demarcated portion of own land, nobody can stop you.
My lord, difficulties is my lord.
Difficulty your client has created.
Kali,
Your
kali, kali, kali,
client by
kali,
his
kali, kali,
letter
kali,
has admitted
Huh?
that
No.
I have made construction amicably, but I will not allow you to do so.
No, my lord, one thing is very clear.
This
No, no, my
muscle
lord.
power will not.
No, no, this is not a public interest litigation, my lord. With
This
due
is-
respect, my lord, how the court can
We will
travel
ask
beyond the scope?
All right, we will ask you to produce all the sanction letters for the construction you have raised.
No, my lord, this is
Will
beyond the
demolish
scope. This is beyond the scope. Kindly dismiss my appeal, but beyond the scope. This is beyond the scope, my lord. Originally, writ petition is there. How the court can bring something which is not even the least?
You have brought it.
Forget about my position, my lord.
No.
Appeal, I am withdrawing the appeal, my lord. I am withdrawing the appeal. I am withdrawing the appeal, my lord. I am withdrawing the appeal.
Withdraw. We will withdraw. Your leave is. You will say that I am withdrawing the appeal. We will dismiss the appeal.
Yes.
Finished.
Yes. Will you do the appeal? Will you do the appeal? He cannot take the advantage of that. Why they have rejected? Why that was rejected? Because if it is wrongly rejected, my lord, of course, my lord will not take trouble to that. Other forum is there.
So if your appeal goes, we are not interfering.
As
Order
you
of
know,
writ could be
I'm because nothing is left. Nothing is left. If that very rightly said, I cannot make any construction, my plan is rejected. His whole foundation of this case based on the sanction plan. If the sanction plan is not there, everything goes. Nothing is left. So my appeal is I need not proceed with my appeal.
We will record that you are not willing to proceed with the appeal,
Yes, that's all.
and we will dismiss your appeal.
As you losses, my
Dismissed as withdrawn.
as you losses. Now develop like
Now let them do whatever they like.
nothing is there. No. One thing is very clear, my lord. Whatever point your lordship is raised, having foundation of the civil law, how can I deny that, my lord? There's correct propositions, but question is, my lord, here is a case where everything is gone. Everything goes. But if they challenge the order of the Podal, then matter will come. If it is found by your lordship or my concerned court, no, it is not rightly rejected, then again everything will revive. Again, I'll have to jump up on your lordship. My lord, kindly see the position. Then all those questions will arise. No, Mr. Banerjee, at this stage we cannot.
Yes, Mr. Banerjee. Mr. Banerjee is
That if my learned senior friend
Mr.
wants to,
Banerjee is withdrawing the appeal.
then
You
my lord,
can
the
have nothing.
perjury statements made, my lord, that has to be my lord, looked into.
What?
My lord, the false statements deliberately, I'll show my lord from the record.
Then you file a 340.
My lord, that my lords can also show more to do.
No. How can
But
they
may
proceed when they are not willing to proceed?
My lord,
with
the
the-
averments remain. My lord, even if my lord, the
Take
proceeding is
advantage of
withdrawn,
that.
my lord, the averments remain. May I just show my lord how my lord they
Just understand, Mr. Banerjee.
Yes, my lord.
Today your plan has plan which was approved on 8th of June 2023 has good, bad, indifferent, whatever be the action, it has been cancelled.
post my lord by writ petition being allowed.
Doesn't matter.
Post your writ petition being allowed. Very
And post my lord, the honorable single judge held that the plan is genuine.
No, no, this is.
I'll show.
The
I'll
No,
show.
no,
I'll
this
show
is
to you.
unfortunate. No.
plan is not
স্যার
genuine.
আমায়
Where
একটু
is that
বলতে দিন, আমি তো
observation?
ডিস্টার্ব
তুমি যেটা
করিনি।
বলছো
আমি
তুমি যে-
দেখাবো তো স্যার, আমি দেখাবো,
যেই
শব্দটা
বলছো,
দেখাবো।
শব্দ চয়ন
Kindly my lord take.
So, Mr. Banerjee, think of this situation. Suppose today Mr. Banerjee says that I will not proceed with the appeal.
But he cannot escape my lord, the consequences of my lord, the perjurious statements made. And nor my lord,
That
this
is a-
honorable
that
court
is a
my lord, should
separate
allow him to.
proceeding you continue with that proceeding. We are not stopping it.
But my lord, if I can show, if I can satisfy my lord's conscience today, my lord, from the statements made by him and from the documents produced by him, that Milord, he has made a false statement deliberately to mislead Milord, the Honorable Division Bench of this Honorable Court. Milord,
Why didn't you disclose the pendency of the suit in your report?
suit had got nothing to do with this. Milord, will show the plaintiff I have
What was
annexed.
the wrong in discussing the suit?
Because
Why
Milord,
have you
that was absolutely irrelevant, absolutely immaterial.
That is your argument.
And Milord,
Mr.
no, I'll show Milord now
There
all
is
the
a
documents.
subsisting or interim order in that suit. also.
No.
Yes,
No.
it was till February 2020.
Milord, 2002 the suit was dismissed.
No, that was your suit. They have filed 601.
Milord, that was filed after Milord the writ was allowed.
Maybe.
How could I disclose that? Where could I disclose it, Milord? Milord, when the writ petition was being allowed, Milord, the suit was not there. Milord, suit took birth after Milord, they sat together after the writ petition was allowed. Milord, this suit, the so-called partition suit, Milord, is an outcome, is a product of Milord, their mutual
So
discussion.
what you are wanting from us? What
Milord,
you
a
are,
stern,
that we will say?
Milord, a stern action against Milord, both the municipality, the panchayat, because Milord will show Milord, the panchayat's version. Milord, the authority, I'm sorry. Just show Milord.
He would have tolerated, but when the appeal is not there, what tolerance?
Milord, somebody, when Milord, he feels that he has got caught, Milord, by the Honorable Court, Milord, he says, I am withdrawing my litigation. Milord, this is
1
possible.
minute, my lord. For this reason, had it been a case, correct. Had it been a case, I have got some beneficial order from the court. Law is very clear.
Yes, there is.
Now,
I have suffered an interim order.
No.
Yes.
Not from here. Not from here.
Milord,
You on your.
He will vacate the
but Milord,
Hypothetically, if I were to-
he has Milord suffered, Milord, he has Milord enjoyed a benefit. Firstly,
No.
kindly Milord allow me to show Milord 4-5 pages how Milord they have Milord colluded.
Mr. Banerjee, kindly satisfy us
Yes, Milord.
when the appellant does not seek a return of
But-
funding on
yes.
his submission. How
I
can
cannot
we-
compel him, Milord, to. Yes, I cannot compel
So
him
we
to
will-
prosecute,
we will
Milord, to proceed
dismiss-
with the
we
appeal.
will dismiss the appeal, we will vacate the.
But Milord, I was just wondering what about the misleading, false statements Milord deliberately made
Remedies
by
are
both of
available
them on oath.
Remedies are available to you. For that, remedies are available to you, Mr. Banerjee.
Kindly, Milord, then grant us liberty, Milord, to initiate because Milord, I have to come back to your lordship again, Milord, with a 340 application. Milord, I need my Lord's kind leave. Without a leave, Milord, I cannot.
Only if it is pending.
I'm sorry, Milord.
40 is only if it is pending where there's a final.
That's why, Milord, if today, Milord, this is allowed to be withdrawn.
There has to be a final adjudication. We have to come to a finding that the document.
Milord, after the Supreme Court's recent decision, this final adjudication is also not required. Milord, that was the old law, Milord, subject to, of course, correction by your lordships. Today, if I can, Milord, show your lordships that, Milord, what is stated on oath and what is, Milord, disclosed from his own document are, Milord, poll Sassender statements. And if my Lord is satisfied that there is a tinge of falsehood,
So we have to come to that.
Milord, that's so apparent.
adjudication.
Otherwise, Milord, I have to again come back with an miscellaneous, Milord, with an application in, Milord, a disposed of appeal. Milord,
Why? You will
I need a leave from your lordships, Milord, to proceed against them.
you have to challenge the cancellation of the deed. Cancellation.
Milord,
of
this
the-
cancellation, Milord, is in the air. Why I say this, Milord? Kindly allow me to, Milord, show those documents relating to cancellation. Milord, if my lords want me, Milord, to come back on any other day, Milord, I'll come back
No,
any
no.
day that is convenient. Kindly, Milord, just have a look at the cancellation, the way the cancellation has taken place.
Suppose it is palpably bad.
Milord, it's not recognized by law. He doesn't have a power, Milord, under the law to recall a sanction.
So we will say that that cancellation of plan. We will say in judicial review that plan is.
Milord, let him
illegal.
show his source of power. Kindly, Milord, ask him to show his source of power.
You are stretching yourself.
You're enlarging the scope of the writ
Then,
petition.
Milord, kindly, Milord, appreciate
The
what
scope
would
of the
happen.
writ petition was you have a valid sanction plan. You are being restrained by certain persons.
I got
police-
Milord a judicial order.
The police is not helping. This was the scope.
And the scope, Milord, when the writ petition was moved, I'm sorry, Milord, I'm troubling your lordships. The first day, Justice Tirthankar Ghosh was pleased, Milord, to ask them to file a report saying whether the plan is genuine or not. That was, Milord, the query that is recorded in the order. That has not been shown by my learned friend. Milord, that's there in the order. Milord, then a report was filed. Milord, seeing the report
By whom?
by them,
Saying?
saying that report was, Milord, placed before the Honorable Single Judge. Honorable Single Judge, Milord, was of the view that the report was not, Milord, apropos the query. Then, Milord, another report was filed. Seeing that, Milord, the Honorable Single Judge was pleased to observe, since the plan, Milord, is genuine, there is a plan. There is no right, Milord, vested in them, Milord, to disturb my construction. So, Milord, the genuinity of the plan was also tested.
Show us the order.
Yes. Kindly, Milord, have a look at page 52.
Was the cost on me.
No, that's not the
But
law.
how can
My lord,
we out
the
of
request of
them very-
respect, that's not the law. I cannot, my lords will not, my lord, kindly permit, my lord, an executive to annul a judicial order by passing, my lord, an executive order after, my lord, the judicial authority, my lord, has granted something.
Show us where it
Yes,
is.
page 52. My lord, this is an order passed by the Honorable Single Judge on 21st of November. Kindly take, my lord, the second
Page 52.
52 of the paper book, my lord.
Yes.
This is, my lord, an order passed by the Honorable Single Judge on 21st of November. Kindly take the second last paragraph. Learned advocate for the state would ensure, in respect of the genuinity, this is the expression I had been using, of the sanction plan and submit a report before the court. So that was tested. Then, Milord, kindly take the next order.
What
Six-
is state? State was asked to file a report as regards the genuine.
Whether, Milord, the sanction plan is genuine or not. Then, Milord, kindly take page 56.
State will not the authority.
স্যার একটু বলতে দিন না আমি
He is not-
আপনি এরকম
state is
করছেন
the sanctioning plan.
এত ছোট বাচ্চা ছেলের সাথে এরকম করছেন কেন পেজ 56 this is the order impugned today before your lordships. Since the sanction plan has been granted by the concerned Gram Panchayat, Champayati, etc., would ensure that no obstruction is created. In the interregnum, 6 December, 21st November order, this is 6 December order. Milord, in the interregnum, Milord, a report was submitted. My lords will kindly get that at page 54. Milord, the desire of the Honorable Single Judge was to get a report on the genuinity of the sanction plan. Here, from the state, Milord, police, Milord, acting for the state, filed a report. Honorable Single Judge said, this is not the report I was asking for. Then, Milord, submissions were made and Honorable Single
What
Judge...
was the report?
I'm sorry, Milord.
What was the
That was,
report?
Milord, taken back.
No, you were there. What did they say in that report?
Milord, that was not shown to me. That was, Milord, made over to the Honorable Single Judge. Honorable Single Judge recorded dissatisfaction.
Yes, very good. Now,
Then, Milord, after Milord, the 6 December order was passed saying that yes, there was a sanction plan and the construction was made in accordance with the sanction plan. What, Milord, the Panchayat did, kindly Milord just have a look at Milord their resolution, so-called resolution at page 294. I'll show Milord 3 documents only. Page 294, Milord, kindly have a look. This is a document, Milord, produced by them, the Panchayat.
Page
294, Milord, second volume. Sir, আপনি ছিলেন এই মিটিং এ।
yes.
Page 294,
Hmm.
Milord, list of attendees are there. The first person is Milord, the president of the club, Oshit Boron Mondol. Now, Milord, kindly see what it says. Milord, may I skip over the first paragraph?
Is it a part of the writ petition, my lord? Is it additional evidence? On what basis he is enclosing all these things in the paper book? That is why he asked for that. No, I'll pay the paper book.
Milord, may I disclose the
No,
basis?
no. Is it a part of the, my lord?
This is.
And I was not a party. I don't know anything.
He is the man.
He is the man. Who is the man?
Oshit Boron Mondol,
Oshit Boron Mondol. Who is
who
the?
was a party in the writ petition.
Who is the party in the writ petition? But what about us?
He is,
He
Milord,
is the Pradhan. As a Pradhan, he has made a party.
Come back to you.
I am really surprised when they withdrawing the appeal is bringing anything.
Milord, this is dated 14 January. Milord, second paragraph says, সভায় সভাপতি জানালেন বিগত 4/6/2023 তারিখের মিটিং অনুসারে পঞ্চানন মন্ডল পিতা এটসেট্রা দাগ নাম্বার সাচ এন্ড সাচ দাগ নাম্বার 2074 এ গৃহ নির্মাণ অনুমতি প্রদান করা হয়েছিল। পরে বিষয়টি ভুল করে গৃহ নির্মাণের অনুমতি হওয়ায় গ্রাম পঞ্চায়েতে শুনানির জন্য উক্ত ব্যক্তিকে ডেকে পাঠানো হয়েছিল। 2 dates are indicated. Milord, 19th of December 2020, 8th of January 19th of December 2024, 8th of January 2025. Milord, these 2 letters, my lords will kindly get at Milord page 228.
What you are meaning to say?
Milord,
This is without
the result.
jurisdiction.
Firstly, secondly, Milord, the resolution says that Milord, the sanction is being recalled because of the complaint lodged. Because of the complaint lodged by my learned senior friend's client, and because of my, Milord, I having chosen, Milord, not to participate in the hearing. These are the 2 reasons, Milord, shown. Kindly turn over the page. The next page, 2-3 reasons are given for, Milord, withdrawal of the sanction.
No, my lord, I am strongly opposing. This is not a cause of actions. How we can challenge and bring all these things here?
Milord, these are the 4 reasons shown for, Milord, withdrawal of the sanction.
Mr. Banerjee, how can we set aside this in appeal, which he does not want to proceed? Tell us one.
Milord, I am not on, Milord, setting aside of this, Milord, withdrawal order.
Otherwise, you cannot construct today.
Milord, I am on the perjurious statements made. I am
No,
showing.
you have to immediately go and take suitable grounds and challenge this order of
That, Milord, I will do. I will definitely
Unless
advise my client.
your parent order remains.
But some
Now,
person.
let us understand.
Yes, sorry, Milord.
Why did we fix Mr. Banerjee on the issue that if it is an unpartitioned property, then how you have raised construction? Now, if we wanted to say you produce every records on your favor.
And then he
To the
escapes.
teeth of such, on the teeth of such query, Mr. Banerjee thought it fit to say that
To
upon instruction I am withholding. So what is the consequence? Consequence is order of the writ court remains. And if there is a sanction plan which has been cancelled, that gives you a good ground to challenge this cancellation and obtain an order,
But I
because
was-
nobody can challenge the order of Justice Ghosh any further.
Absolutely.
Withdrawn.
Absolutely. But Milord, the only thing that
And
is,
you
Milord,
take all the points of perjury
Definitely I will.
statement, illegal statement of the
Milord, if a
Pradhan.
perjury is committed before your lordship's court, possibly, Milord, I need a leave
That is
from
what
your
my
lordship's
brother
court.
is saying, that requires adjudication, Mr. Banerjee.
Even if it's prima facie.
That can be done in a second, Milord. In a second, that can be done. Milord, I can show it. I can show it. My Lord Justice, Milord, Chakraborty, Milord, was referring to that, Milord, amicable, Milord, possession issue. Milord, that is the basis of the partition suit also. In the plaint of the partition suit also, they have said that, Milord, we are, Milord, in exclusive possession of this part of the unpartitioned land on amicable settlement
Sir, if
basis.
once you challenge this resolution of cancellation, they also won't be able to take the ground of the subsequent interim order which has been obtained. Because the Reed Court has already said that there is a genuine sanction plan and police
The
will
only
implement
thing, Milord, that is. পারবোই না মনে হচ্ছে দিলে বেটা। Appeal, Milord, on the
So,
specific.
Mr. Banerjee, are you saying that this is a fraudulent document?
Yes.
This one,
Yes.
294.
Yes.
Why?
Kindly, Milord, turn to. Milord, this document refers to two notices which were allegedly served on me and I did not participate in the hearing. Milord, these two alleged notices are at page 228.
But how it becomes a fraudulent document?
I tell your lordship, Milord, I will show it to your lordship.
We will
Milord, may I raise the point first? Page 228. Milord, I say this has been manufactured because, Milord, there is not a single, Milord, semblance of proof of service or attempt to serve on me. Milord, this is the single page document which was placed before your lordships along with the report. Without, Milord, explaining as to how, Milord, this was served on me. It's not their case that was attempted to be served and I refused. They say, despite receipt, I did not participate. Milord, kindly allow my learned friends, Milord, to show that this was, Milord, even tendered to me. First, Milord, there are two notices. 228 is the first notice, 229 is the second notice, which are all manufactured only for the purpose of this litigation. This kind of notices were never there. And Milord, just kindly have a look at the date of the notice. 19 December. Milord, 19 December, the partition suit is filed. Because, Milord, summon is issued on 23rd. So, Milord, had there been a partition suit already filed, Milord, in his complaint, he would have referred to the partition suit.
complaint to whom?
Complaint to the Panchayat for cancellation of my sanction. After, Milord, he suffered a defeat. I say he suffered a defeat because he was a party to the litigation. Ashit Bodhan Mondal was a party to the litigation. He did not appear before the Honorable Single Judge. And after the order was passed, Milord, there was a complaint lodged. The complaint makes no whisper about the partition suit. These are, Milord, the alleged notices which were manufactured for the purpose of this litigation and were claimed to have been served on me. Then, Milord, the resolution says two reasons only for withdrawal of the sanction. One is these complaints and second is my non-participation. Milord, unfortunately and shockingly, Milord, when my lords wanted a different, Milord, another report from my learned friend's client, the report says it was withdrawn because side open space was not there. which is not there in the resolution. So they
Yes,
now understand they are trapped.
that is page 295.
Yes. Kindly, my lord, have a look at the resolution once more. My lord, 294 is the resolution. My
4 reasons which were given.
yes, 295.
Hmm.
My lord, side opening space is not there. Adequate opening space is not there. Those things are nowhere there.
No, no, clause 5.
Yes.
The niyom, what is written? চারদিকে জায়গা নেই.
My lord, this is an addition letter. My lord, kindly just have a look at 1, 2, 3, 4 and then see how my lord 5 is written.
No, no, what order do you want from us, Mr. Banerjee?
My lord, I want my lord a leave to my lord proceed against them for my lord making perjurious statements. My lord,
We are not going into that. Come with an application, we will consider. But in a,
then my
in
lord,
a-
I have to trouble your lordship once more. I did not want to do that. I wanted
no,
very
no,
well. I'll do that.
not question of
I'll take out an
troubling, it is a
application.
you have to remove the first. You have to remove the hurdle of this document. It is very
My lord,
difficult in an we are in judicial review of the order. It is very difficult in an appeal file.
now my lord,
The
so
basis
I'm sorry.
appeal file and appeal he wishes not to proceed. We can impose cost upon
my
it.
lord,
That we can do. But question is that
that my lord he deserves. No
No,
doubt, my lord, that he deserves.
had it been a question of restitution, we could have understood that it was there by filing the appeal, it is nullified. Now, on paper, there is a good, bad, indifferent, there is a cancellation of a plan.
Number one. Number two, last sentence. My lord, his appeal is my lord based on the assertion that this is unpartitioned property.
That we have already told.
Deeds say this is partitioned. All the deeds say that this is partitioned because all the deeds have a schedule. All the deeds have a plan with a red boundary. Well, the first statement forming the foundation of the appeal is a false statement. First statement.
Partition ওইভাবে হয় না।
স্যার আমি এই জন্য বেবি পোদ্দারও ক্যারি করছি, হ্যাঁ পার্টিশন কিভাবে হয় সেটাও ক্যারি করছি, যদি বলেন দেখাচ্ছি। Well, as president is here, Ashit Baron as Pradhan is there.
Personal capacity. But I am appearing as Pradhan.
What is your name? Ashit Bora. Yes.
But I tell you, Lordship, that the stream of justice has been polluted by themselves, the appeal petitioner himself. Why? But
You are a president of the club.
no.
Not now. He was. At the material time, he
So
was.
when the sanction plan was given, you were the president.
Yes.
No.
When it was approved on 8th of June,
Previous
I have taken instruction correctly, my lord, that whether at that time I was there,
Mr.
I
Sen,
did or not. But
ask,
I can say,
ask yourself to better be careful, not to play
my
with
lord,
the court.
I can tell only one thing, my lord, before your lordship, that in the writ petition, plan was annexed. Half portion of the plan was annexed. Not the entire plan which was submitted for sanction. It was not. It has not been annexed to the writ petition. For your lordship's kind comparison,
Where is that reason given in the cancellation?
reason given, my lord.
Show us that reason you have given?
My lord, I tell you, lordship. 295.
Yes, where is that reason given that the
Tell you, lordship.
Hmm?
295.
Hmm.
That number one. or why?
Yes, where is the? No, your argument is it was partly portion was approved, not the entirety. What you are saying? Huh?
That is not in there. I'm telling that from the writ petition.
What is your stand? That the approval which was granted, that was approval of a portion. He is trying to construct beyond.
I'm first telling that as a whole was not annexed. I have annexed to my affidavit in reply. Apart from it will appear that it is a commercial building, proposed commercial building, and in that plan it has been shown the setback and side space and front space, how much to be kept open.
What is the date of that
sanction?
Huh?
Sanction date is, my lord, approved plan 8th June 2023. 8th June 2023.
So now, you after the writ court held that this sanction plan is valid and you can construct, you were made a party. Now suddenly when the order was passed, you took a resolution that that plan is bad. Having relied upon that for so long years, 2 years, suddenly after the order was passed, you go and take a resolution on a alleged plea that he did not appear on notice.
The basis of the representation made by the craft.
Huh?
The basis of the representation made by the craft.
So you will not record in that they are this challenge that the entirety was not approved. Only a part of it was approved.
I am more than sure that had this plan in its entirety been annexed, you will kindly.
If they come in 340, we will consider.
Before that, kindly consider. Had this entire plan was submitted before the honorable single judge, my lord, probably I cannot say sure. Probably, my lord, it could not be recorded in the order that plan was sanctioned. Not my lord, recorded genuinely or duly, not recorded. Why, my lord? I am, my lord. Law provides, the rule provides. Well, kindly see, but the rule provides that setback is to be kept.
He will challenge that order. You face the challenge.
If they challenge.
They have no other option but to challenge. They will have to challenge. Now, question of 340, if he intends to go on that, then he will face this argument that there was no adjudication.
Absolutely correct, my lord. This is not the stage.
Kindly,
I don't know why they are raising all this point here.
How wrongly the plan was obtained, sanction of the plan was obtained. How
In course of hearing Mr. Banerjee, learned senior advocate,
Milord, possibly my learned senior friend's client deserves some, Milord, something more. 3 days argument. 3 days argument. It should be.
May I leave, my lord?
Worship, I'm for the respondent.
Oh, there, which they did not agree.
Point involved, my lord, it's a pure question of law that is involved. My lord, the question of law involved is, my lord, whether a new consumer who comes into the shoes of the erstwhile consumer by purchasing the property in liquidation or otherwise is entitled to pay the old dues which the erstwhile consumer had. This is, my lord, the short point. There are two regulations which will fall for interpretation, and there are two to three judgments of the Supreme Court and also one judgment of a division bench, my lord, which will fall for consideration. Now, my lord, by the order under appeal, my lord, the learned judge has held that a purchaser who is coming in and purchasing the property is not a consumer within the meaning of the act, and therefore the restriction on the consumer so far as this matter is concerned, it may be academic as of now.
If we remember
Because
correctly, they
that-
had agreed, they had said that we are running our unit, we are not taking
Correct.
electricity
But
from
my lord,
PEC.
my lord, today it is not a question of only them. If they don't come, my lord, if they don't want connection from me,
You can file a suit and recover whatever dues.
no,
if at all.
my lord, it's a question of law. Because, my lord, if this law remains as it is, my lord, in every case, until, my lord, my lord, lordship will set the law, my lord, will decide the law in the division bench, my lord, this judgment will be staring on my face that, my lord, somebody will go. Now, my lord, the IBC route is there. It is, lordships are aware, my lord, it is being abused more than, my lord, it is being that. So, my lord, they will come, and, my lord, the contention will be, I have come with a clean slate. I am not liable to pay all these dues. But there is a specific, my lord, to protect this mischief, there is a specific, my lord, regulation which is, my lord, there already. Now, it is only a question of interpretation, and according to my respectful submission, I will try to persuade your lordships that, my lord, here is a case, the distinction is subtle. My lord, if, my lord, for the purpose of deciding whether the premises has connection or not, the test is not whether there is live electricity. The test is whether the gears are there, and only, my lord, an operation of switch, my lord, the connection can revive. Here, my lord, if it falls in this category, my lord, I am covered by the division bench judgment, my lord, and which was upheld by the Supreme Court.
Yes, where is your senior?
My lord, I'm being led by Mr. Chaudhary, Mr. Jishnu Chaudhary, my lords. He is on legs, my lord, before.
So sometimes he has to be before us. Na? Mr. Chaudhary is there on every occasion.
My lords, we can come back on any day, my lord.
That way he cannot proceed. Na? Every day you take adjournment and you go out. বিষ্ণুতে appear করছে। কে ছিল?
Didn't Mr. Mitra appear? Mr. Siddhartha Mitra appear one day before us?
My lord, in the trial court, I understand Mr. Mitra had appeared, my lord,
Even before us, I remember he appeared on one.
one day.
Yes,
Yes,
my lord. He was
lordships
there
are
on
right.
last occasion. he was
Lordships are right.
there. Mr. Chaudhary was there as well, my lord.
No, so where's Mr. Mitra?
Mr. Mitra is not there today.
Not there. How long will you take, Mr. Jyoti?
My lord, at least an hour.
Problem
The
is,
lordship can keep it any day when they are there, because my lord, it's an interesting question of law, and my lord, our endeavor will be to get the law decided one way or the other, so that we know where we stand.
It will be the first matter in the next combined list. We will record that, and if you come, you come, otherwise.
Very well.
Heard Mr. Chaudhary, learned advocate, appealing for yes.
Respondent in this matter.
Your respondent.
Also.
দেখি ফাইলটা দেখি।
ওই জন্য ফাইলটা দেখতে চাইছি।
go to appellant to adjourn.
Records reveal
And
that an adjournment was prayed for on behalf of the appellant
Number 4, my lord, I am appearing on behalf of the petitioner, my lord, led by Mr. Onindulai. He is on his legs before court number 30, my lord.
Sir, every month we cannot adjourn.
But
Who is your other side?
that side, my lord, someone contacted me today, but now it's
Next monthly list. Yes.
yeah, I'll let me
Oh, item number 4, I'm for the state. I'll,
4.
Huh.
5. Yes, you are for the
I'm for the 4.
previous matter.
previous, madam.
The
Previous-
Panja was there. Oh, item number 4.
আমাকে
Next
কত
month,
টাকা
please.
দিতে?
Yes.
At 5, I appear for the respondent.
On the last occasion, my lord, we had filed our opposition. They were supposed to file their reply.
No one there for petitioner,
No, no, I'm not finding anyone.
appellant.
I'm also for the respondent.
Records reveal that no one appeared on behalf of the take care of
Milord, I'm for the appeal.
appearing for the respondent petitioner. My not state respondent.
appellant. You are the appellant.
Milord,
The application
This
has
is
been
for-
filed, my lord, not in proper form.
Lordship,
What are the applications?
application for 1, 3, 4.
1, 2, 3, 4.
One
2 is stay application. 2 is stay application.
and what are 1, 3, and 4? What are
One-
those applications?
One is section 5 application to the appeal. 3 is the substitution application, and 4 is abatement and recalling of abatement and
That's not the form, my lord.
section 5.
Huh?
Milord.
Substitution application would be filed within 3 months. Thereafter, setting aside amendment 60 days.
Hmm.
Then section
With
5
section
is with section 5. He has not.
Lord.
He filed the application not in proper form. That is why, my lord, I am saying. Apart
Which
from
application is not in proper form?
substitution application by setting aside amendment, he filed the application for substitution.
By not-
Substitution application within
Are
not
you opposing that? You will hear on merits.
thereafter, my lord, another writ petitioner substitution application would be required, my lord. Kamala Das Adhikari, petitioner number 1, wife of the petitioner died. Kindly,
He has also died.
he has also died. They are residing, my lord, within the 100 meter within the periphery of the petitioner's house.
Within
This-
peripheria
100
Not
meter
to-
of
of the petitioner's house.
Separate.
They know everything. They are the invitee of the funeral ceremony, but they did not file the substitution in
They
proper form.
also, my clients will come and meet here, but
My lord, may
no, they are saying that they are in the same area.
may I be allowed to?
I came to know from Mr. J.C. Das, here he is appearing
তোমাকে বলবো কেন আমার বলার তো
Kamala
কথা
Das
নয়
Adhikari
that
died.
আমার বলার তো
It's
কথা নয়
expired.
only
Kamala Das Adhikari, the wife of petitioner number 1, Radhasam Das Adhikari,
আচ্ছা দাঁড়াও।
on 14th May 2025. January, February, March, April, May.
Kamala Das was a party.
yes
Yes, my lord, substitution application he has filed.
I have
that is not my
filed substitution application and he is now saying that
So before that could be allowed, another person has
another
expired.
person has died. What can I do?
my lord, may I be
What's the order? What is the main matter about?
Oh, main matter is about Miller. My clients are applicants for pattas before the BLRO. And their land has been, their big riots, their land has been vested in the year 1967.
So if another person has died, you take appropriate steps.
Lordship.
Sir, may I tell you also, may I be allowed to say something? I tell you.
Let them file, it is not informed.
ঠিক আছে, তখন
Mr.
Lordship, again I file up.
You are Mr.
Soyod Chandan Hussain.
Mr. Hussain Learned Advocate appearing for the appellant.
মাস টাইম নিয়ে নে,
Prays for an accommodation to take appropriate
এক
steps.
মাস টাইম নিয়ে নে, রেডি করতে।
Thereof, let the matter go out of the list for the present. Stop liberty to mention. We notice to
Lordship, next month's list, within that I shall
you
file.
mention you file with liberty with notice to the response.
Kamala is the wife.
Opposition do. My lord, by this time I will file opposition, my lord. Yes.
Kamala is
How to think.
the
Kamala's other heirs are on record. Then
Others are on record.
then what will be the problem?
Then
My lord,
Kamala may be expunged from the.
They file an application. He should make an application for noting the date of death of the one of the subsidiaries. By this time, my lord, I will file opposition, my lord.
Yes, you file. We are not stopping you.
Yes, ma'am.
Yes, next.
কি কাগজটা দিয়ে?
My lord, item 7, my lord, I appear for the appellant. My lord, I need to seek instruction from the client whether to proceed with this appeal or not. My lord, I am humbly praying before your lordship to grant me a fortnight time. By that time, I will be.
My lord, paying for the respondents in this matter.
কি order ছিল?
I have not been able to establish any contact with the client.
পরের মান্থলি লিস্টে রাখো না? হ্যাঁ, বলে দাও।
No material instructions.
My lord?
No material instructions.
No, my lord.
My lord, in that event,
I am being led by Mr. Shagor Bandyopadhyay. That's why, my lord.
My lord, in that event, if my lord kindly keeps it in the next monthly list so that I'm paying for the respondents in this matter.
So we keep it as to be mentioned. When do you want to? When
Lord,
can
kindly keep it on next month's list, my lord.
No, no, no. We will unnecessarily not keep the
My lord, then,
matters.
my lord,
Last occasion
after a
also-
fortnight, my lord.
এটাকে টু বি মেনশন রেখে দিও, ওই সপ্তাহ বলছে 3 সপ্তাহ রেখে দাও। It will appear under the এটা order. Mr. You are Mr.
Partha Banerjee.
Mr. Banerjee, learned advocate appearing for the appellants. Prays for an accommodation to avail necessary instruction from
Item number 8, my lord, I'm appearing for the respondent.
state appeal. State appeal.
My lord, I am appearing for the respondent.
Yesterday, Lord, I have been engaged.
Lord,
by
we
the
were
Lord,
taking the point of maintainability, my lord, the last occasion.
Lord, Lordship, earlier, if your Lordship kindly see, Lord, 125, the order impugned.
What? You are not ready today?
No, Lord, yeah, just now, Lord, I have
Next monthly list. Yes, next.
not next month, it is, my Lordship, kindly consider this. Lord, yesterday, I have been informed to appear because earlier occasion, if your Lordship kindly see, Lord, page 125. Page 125. Kindly see, Lord. Kindly.
If you do it,
Then, my lord, then, my lord,
Kindly see 125 only, but I want to show
the one name, your lordship kindly see.
One name.
দাঁড়া ভাই আমাকে বলতে দিন ভাই। Lord, 125 the order impugned. Earlier learned advocate general appeared in this matter, Lord, along with Amitesh Banerjee. Lord, yesterday, Lord, I have been instructed by the learned government pleader to appear along with the learned advocate general. Your lordship kindly, Lord, fix a date, Lord, after 10 days, subject to lordship convener, or 7 days.
No date can be fixed.
Or Lord, next week, Lord.
Next monthly list, yes.
But your lordship will not give, Lord, 7 days time. 7 days time.
No, Mr. Van. Let it come on the next day. You get ready, you argue, we finish it up.
Yesterday night, Lord, I have been informed.
Yes, yes, you take your
That's why, Lord, I am playing 7 days time, Lord. 7 days time. Because I will pay, or Lord, Thursday, Friday, subject to lordship convenience.
No, again adjournment will be taken.
No. I will not take it. Because it's a very short
We
point.
are keeping matters in the supplementary list. The junior appears and says advocate general is not here.
Then your
So
lordship
it is a
kindly.
useless formality of keeping.
Then
Because if it appears, you won't argue without Mr. Dotto.
Then, lordship kindly takes up the matter, Lord, I will place the, Lord, the order in
Then, my lord, before they do, my lord, because then I have to take the point of maintainability. So, my lord, I would, my lord, then start because I'm taking the point of maintainability that the intra-court appeal is not maintainable, my lord, for your lordship. Yes, my lord.
Mr. Banerjee, we have done this. We are also embedded. We keep it in the supplementary list. People are not present.
I will do this case. I will. Lordship kindly give 7 days time. I will. I'll come with him, Lord, proper, because it's a very short point. Short point. Whether 5 FIR registered and Lord, other accused persons have been granted bail, they've arrested, granted bail, but this person, Lord, has been, Lord, the.
All right, 22nd July. Yes.
22nd July. I'm deeply obliged to your lordship. I'm deeply obliged to your lordship.
Also addresses on the maintainability issue, Mr.
My lord?
You address on the
Maintainability issue is what I'm raising.
Since Mr. Mukherjee is taking that point first.
But we have also taken the maintainability in the writ petition also. That was not hard.
Yes, next week.
Anyway.
But he has taken the maintainability of the, Lord, the appeal here. And in the writ petition, Lord, I have taken the maintainability.
No, the letters patent act is there. The Supreme Court judgment is there.
Yes.
Coordinate pensions judgments.
Lordship also, Lord, take that point also.
Yes.
I'm deeply obliged to Lord. And Lordship, kindly pardon me, Lord. I have, Lord.
Yes. Now, file this.
Can one to park on.
From date of communication according to bearing to all the
No one appears on behalf of the appellants and no accommodation has been sought for.
Lordship, I am appearing on behalf of respondents. Actually, learned counsel is coming. Kindly pairing for short passover. Just
Lordship, because this is a bank's appeal wherein I have already paid back the money to the auction purchaser. This is a issue is with regards to the interest, whether they are entitled to the interest which they have received for the amount which they had given.
I am not brief on this case actually. The learned counsel is coming, pairing for short passover.
Who is your counsel?
Ratul Dash, Mr. Ratul Dash. He's coming.
With your Lordship, Steve, my senior is here.
So let him start. Call Mr. Ratul Das.
I'm calling. He is coming. He's coming.
He's coming. So let him start then.
Okay, I'm calling.
Yes.
Well, this arises out of an order of 14th of July 2022 passed in a writ petition filed by the auction purchaser. I'll briefly, my lord, give your lordships the background. The impugned order directs the bank to refund the money. My lord, the impugned order, lordship will find at page 171. It starts, my lord.
We get it in the memo of appeal.
Yes, lordships will get it in the memo of appeal.
Yes. You are for UCO Bank.
I am for UCO Bank. May I just place the impugned order once, my lord? I'll not trouble your lordship with the entirety of it, but kindly takes, my lord, the first page, first para 1. Petitioners have challenged the impugned action of UCO Bank in forfeiting the money put in by the petitioner for purchase of the property of the borrower.
We don't get you. Paragraph
1, my lord.
The present writ petition starts.
Lordship is looking at, my lord, MAT 1843. My lord, that's the second, my lord, writ petition that was filed for implementation of the order passed in the writ petition. So if your lordship takes the appeal.
So you are in appeal against which order?
My lord, both. My lord, the first order was for a direction upon the bank to refund the money. The second order was, my lord, in an application filed in that writ petition seeking implementation of that order. So if your lordships take 1339 first, that is the parent, my lord, order.
14 July order.
Yes, my lord.
Page?
My lord, lordship is looking at from the stay petition, page 171.
171.
1.
In the memo, you have not annexed that.
In the memo, Mr. Dattu, you have only challenged the order of 25th of August.
That's, my lord, the other appeal.
No, there are no appeal. One appeal you have filed. Challenging order of 25th August.
My lord, subject to correction, my lord. There are two appeals.
Oh, there are two appeals.
Yes, my lord. Lordship has the memo of appeal of the first matter. If lordship takes 1339, that memo of appeal, lordship will find the.
You are placing which matter? MAT 1843?
No, 1339.
What?
1339. Because that would be the parent order, my lord.
So you will place from 1339.
Yes, my lord.
Before my learned friend takes my lord through the entire proceedings, there are certain subsequent facts with regard to the implementation of the order. The order has been implemented as on today, and the money has been already remitted back to the petition, the original petitioner. So, my lord, perhaps in this writ jurisdiction,
No,
whether
he was saying interest.
It is only on account of interest whether I am entitled to get back from him.
Oh, get back.
Get
Yes.
back, my lord, but
Because
there
I
is-
did not have a stay, my lord. So the order which was, my lord, passed by the learned single judge, which was subsequently directed to be implemented, my lord, has now been implemented. So it's really the appeal. If I succeed finally, then I may get back some interest. It's, my lord, public money. If lordships are with me, I know I may not be able to succeed entirety.
Did you pay it back?
in 2023,
My lord, in
after this order,
23 after the order.
around October 2023, my lord, now the whole issue would be whether
After that, the appeals were filed. Or
the appeal was filed previously. But despite the pendency of the appeal and there being no stay, the order proceeded and it was implemented.
Proceeded means you
the-
proceeded in contempt.
No, my lord, I had filed a second application, which is the order of 25th August 2023. I had filed an application for implementation of the first order of 2022.
Right.
And my lord,
That
the
order was also passed.
upheld, and a officer was appointed for the purpose of ensuring a receiver was appointed for the purpose of recovery of the amount, because there was a question with regard to the quantum, because a sum was allocated and thereafter there was a delay in payment, for which I was
in July 22 was the first order.
My lord, 14 July 22 is the
And
first
the
order.
next order is of 23, no?
25th August 2023.
25th August.
Yes.
Now, when was the amount refunded?
My lord, the amount was refunded around October or November, my lord. The exact date I shall give. Exact date will refunded.
So
But
now
my lord,
they have, what is the quantum of interest they have returned?
My lord, the quantum of interest is in relation to what was awarded in the order of 2022. And my lord, even for that quantum of interest, if my learned friend is challenging, that is a disputed question of fact.
কবে টাকাটা গেছে দেখতো ব্যাংকের মেলটা পার করো
And this is
we have to allow him to argue.
Very well, ma'am. Because my lord, the issue would be, it is not with regard to me refunding any amount to them. The issue, if there is any such amount which is to be refunded, that it becomes a disputed question of fact. Because whether this interest is at all payable to them, my writ petition was solely limited to the extent that I am entitled to a particular amount which is to be refunded.
Was there any direction to refund with interest?
Yes, my lord. My lord, because
My lord, just to answer your lordship's query, when was the amount refunded? It was pursuant to an order passed by the division bench, order dated 29th September 2023. My lord, the direction was that the appellant bank is directed to comply with the order dated 25th August 2023, impugned in MAT 1843 of 2023, making it clear that compliance of the order shall be subject to the outcome of the appeal in MAT 1339 of 2022, which shall be heard along with this appeal. So, my lord, therefore, my lord, we had to, my lord, give the money. There might be only one issue, my lord, which I don't have today. If lordship wants, my lord, I can bring that. Is, my lord, lordships may, if lordships are with me, require a computation of the
That's exactly
interest.
what we were thinking. The
Yes, that is-
quantification, you have to make that quantification.
Yes, so that will not be available from the appeal papers because it was not there before the trial court also. My lord, we have to prepare a chart, my lord, indicating what, according to us, would be the interest component that has been excess recovered by the auction purchaser. My lord, the issue was, my lord, that there was a sale conducted by the bank in respect of two properties.
The 14 July order is quite
the sale was
against you.
Yes, I know, my lord. That is there. But
2016.
the observations, my lord, were made by the learned single judge on the premise that the bank is deliberately not returning the money which was realized from the auction purchase. My point would be very simple, my lord. If there was no stay of the sale conducted by bank and the auction purchaser had deposited 100% of the consideration for property one, my lord, was it required for the bank to, my lord, return the money when the bank was only prevented from confirming the sale by reason of an order passed by the learned debts recovery appellate tribunal? Where was the bank at fault? Is the question that has to be decided. Because, my lord, I could have executed and confirmed the sale, I could have conveyed the property, but for the order of DRAT, I could not do it. Now they say I am entitled to interest for that period also, and I have been penalized for that also. And for the second property, he had paid only 25%. When the DRAT, before the debts recovery appellate tribunal, I succeed, I tell him to deposit the balance money in terms of the terms of sale or the terms of advertisement. He could not. But this money was also directed to be paid with interest. Under the terms of the sale, I had a right to forfeit. This would be the question for determination in this appeal. And if I can convince your lordships, regarding the interest component, then the question would be what would be the quantum of that interest. If lordship wants, I can come with a calculation, irrespective of the fact that lordships may allow the appeal partly or may not. But this would be the question, my lord. That's not there, my lord.
That was preliminary.
Because this has happened, my lord, pursuant to an order after the second implementation order. It was August 23, and this order of the division bench was September 23. So naturally, the computation could not have been there, my lord. But I can come with the computation if lordship gives me some time, the interest, and I will restrict it to the amount which I say was wrongly realized or excess recovered. He may be entitled to a part of the interest, but not the entirety of it as directed by the learned single judge, to be very fair, my lord, to his client as well.
My lord, there are twofold submissions which my learned friend has made. First, with regard to whether the
file a supplementary
my lord, the issue would be, my lord, this particular question of interest was at large after the first order was passed, and they had challenged that order. Even when the second implementation order was passed, there is no such specific ground with raising this particular issue that the excess interest has been computed. After the payment has happened, after filing of the second appeal, now they are coming up with another point which is even rendering the first two appeals redundant. My lord, the issue which they allege that this interest was not payable was never raised even at the time of implementation or the second appeal which was filed. Even at that stage, they do not really challenge the computation. They simply go on the fact that whether this could have been implemented by another application in a disposed of writ petition.
To be computed. Either ways, it will have to be computed.
It has to be, my lord. I have
to be crystallized and quantified.
For my lord, even for that particular purpose, my only contention, I understand that my lords will allow them to file a supplementary, but my only contention or the point that I'm trying to make out is this fact was not raised in the appeal originally, although this fact had come to light and this was an issue which ought to have been a part of the second appeal.
That is because they challenge the entire order. No?
But they challenge the jurisdiction of the order, but they do not challenge the interest that was awarded at that stage.
That is they are now saying we have paid back the entirety court's order, but the interest amount which has been refunded, can they claim back that amount also?
My lord, I understand that they have
that your argument will be this,
my lord,
but ultimately it boils down to, suppose we hold in his favor, we cannot keep the doors again open.
I absolutely I appreciate.
Say now they all right, 5 rupees they are entitled, you give back 5 rupees, finish it off.
My lord, I believe that my lord will grant them an opportunity. I believe that, but my second point would have been that this entire issue that they are alleging with regard to why interest was incorrectly imposed, for that there has been proper consideration of such facts, and
that's going into the merit.
Trial that goes into the merit. The trial court had come to the observation that there was certain illegality.
Is exactly my point. I went into the merit. That is why I have filed my appeal. Since it was directed. Interest computation to so
the first appeal first prima facie prima facie in the first writ, the court came to an observation that fraud was perpetrated in not communicating the DRT order and there, despite that, receiving the amount. And my lord, in that light, the second appeal becomes redundant.
There's no fraud on the
My lord,
part of the bank.
in that
We
light,
have
my
been
lord,
very clear.
in that light, my lord, the second appeal also becomes redundant. If they are challenging only the interest computation, that goes back to the appeal filed in respect of the 2022 order. The second appeal was only filed for the purpose of implement. The second application was filed.
The coordinate bench granted protection to them.
Indeed, my lord. But the second appeal, there is no finding with regard to further interest. It is only for implementation. The first
2 weeks, my lord.
No supplementary affidavit.
I can come with a chart, my lord, if lordship permits. But the bank officer who was involved, my lord, the person may not be there. I will take some, my lord, time. 2 weeks gives me, my lord, to come back with that calculation and keeps it any day, my lord, we can have it, my lord.
So you make that computation, it is a chart, you hand it over to Mr. Das.
Yes, I'll do that.
এটাকে তাহলে ওই
Of execution.
কতটা
Is what we always see.
keep it on 22nd July. Oh, 29 July.
2 weeks to 22nd year. That's too short.
29 July.
Is it my lord pleasure that it only should be in the form of a computation, or I survey with an affidavit?
No, you can.
Because somebody must take a responsibility of that chart.
One chart will suffice for both. It need not be a
Yes.
separate chart.
Yeah, no. One chart will.
In fact, your second appeal, whether at all of any efficacy, will depend on the result of the first appeal.
Except on one question, whether in a disposed of writ petition, an application for execution is maintainable or not. It's a question of law.
Wasn't a separate writ petition?
No, it was a can filed in a disposed of writ petition. Though we have been taking advantage of that judgment, my lord, in other matters, but that's a question which is a, my lord, question, my lord, we have urged in the other appeal.
Well, my lord, the judgments and everything is there. If that point is taken, then the second appeal has to be heard. I
But
shall
if I
argue
partly
because the
succeed
judgments
in
are
the
there.
first appeal, maybe that gets diluted, my lord, to be very honest.
সেপারেট অর্ডার শিট ছিল, দেখো তো ইয়েটা ইন্ট্রিং অর্ডার আছে। Which one is the first appeal?
My lord, Mat 1339 of 2022. If lordship permits me to file a supplementary there, that will suffice, my lord.
Mr. Dottulan, advocate appearing for the
That I beg to appear for the respondent. Respondent number 6.
Please. No scope for interim order. So I not always trouble the judges. Sometimes I give relief to judges also.
What are the two applications, Mr.
He says two applications. He says
to appeal.
no, leave to appeal.
If to appeal allowed,
That I cannot recollect, but long back. Because there is no necessity of interim order, that's why you forgot everything.
জানি না আমার মনে করছে লিভ টু অ্যাপিল এলাও হয়েছে
Allow হয়েছে? দেখ না, বুড়িকে বল না।
কেউই জানে না, সবাই ভুলে গেছে দেখ না allow
তুই
হয়েছে।
যন্ত্রকে জিজ্ঞেস কর না।
যন্ত্র জিজ্ঞেস করতে হচ্ছে তাই।
order has been complied with, Mr. Vasu.
Yeah, I'm saying so. I want a decision from the Premier High Court of the country that whether I am in possession of a property of port trust without adhering to PP Act, I can be thrown out by kick. This is the only point I want this court to decide.
Kicked out.
Kicked out. And see the order? Yes, see the order impute.
We were not made party.
See the order impute.
Rank trespassers.
Rank trespasser. Who will decide that? There is a definition in the Act, illegal occupier, which includes the rank trespasser.
I will also place judgment of different high court which says I can.
Only kick. Yes, let us decide
But,
that.
leave
No,
to
why
appeal
have-
has not been allowed, Mr.
Can you allow me? Can you allow this? I cannot remember, my lord. Sorry, my lord. I should
Let kindly have a look at the order dated 26 June 2024 where he was a party.
28th June.
No, my lord, 26 June
Party ছিলাম? তাহলে তো ভালো, I leave that
he filed an application for intervention also.
The leave to appeal has been allowed.
Oh,
I'm grateful to my lord.
But have you exchanged affidavits? Those there were direct.
I have filed the opposition.
You have filed.
I have filed opposition. Reply here.
On this paper, my lord, can you give us a date? Any day suit, my lord.
No, you
This is the only point.
come with a paper book, Mr. Vasu.
Book may not be necessary. He is admitting I'm a rank trespasser. I go by that.
Put it in a paper book, it becomes
Yes.
convenient.
There is a difficulty. My lord has seen this person has been thrown out.
You are admitting you are an encroacher.
I am saying I am saying I am deciding they are doing business for long.
No, but you are saying that you are admitting that you are an encroacher. Yes.
Even if I'm going to that extent also. They have, my lord. Well, I want a decision from this court. I want a decision from this.
স্যার ওটা বলুন রিট পিটিশনের প্যারাগ্রাফে পার্টির নাম লিখে তাদেরকে পার্টি করছে
বরং দেবে
সব পরে Then,
Present
madam,
appeal has
if
been
that is
deferred.
accepted by the court, then kindly throw this PP Act into Ganges.
The
Oh no, in
present-
Jamuna, because of the
My lord, I am appearing on behalf of the respondent number 2, the Registered State Dispute Redressal Commission.
My lord, I'm the appellant, appearing in person.
Lordship,
You are in person.
Yes, my lord.
Lordship, Mr. Devashisha is appearing on behalf of respondent bank, Lordship. He is not come today. So I'm praying for not today, Lordship. Kindly.
My lord, so many days. This is an urgency matter, my lord. Kindly fixed. Day after tomorrow.
What is the urgency? Why
My lord,
didn't you
my lord,
appear
I did
last month when was your called? It was so urgent matter is running in the list
My lord,
for three
I'm seeking.
consecutive months.
Yes, my lord.
It's appearing in the list for 3 consecutive months. And you are saying today that it is very urgent, fix it on this.
Actually, my lord, last month called all the matter, but that time I was in another court. That's why there was some problem, my lord.
Next monthly list, yes.
My lord, just one.
Next monthly list come ready, no chance.
Next month.
Yes.
Kindly fixed any of the date. Otherwise,
cannot be
because
done,
my lord, just one. I did not get the car, but EMI already deducted.
Yeah.
I did not get the car, but bank EMI deducted from my bank account. This is the problem here.
My lord, there is an alternative remedy section.
Now they can file the copy. Yes, please here. Yes. You are for whom?
I am for the respondent number 2, the Registered State Consumer Dispute Redressal Commission.
He is coming against the order passed by the commission.
Yes.
Huh?
Thereafter, my lord, he has prepared a writ application, and learned single judge did not entertain his writ application. He has preferred an appeal against the order passed by the learned
Not
single.
entertained since it was passed by the commission.
Yes, my lord, because there is an alternative remedy. He should approach under section 58 of the Consumer Protection Act. There is a forum is there. He must approach before the National Commission.
My lord, due to a dispute over the delivery of the car, I filed a consumer complaint before the District Consumer Commission at Baraipur South 24 Paraganas. My lord, the main problem, the president of the District Consumer Commission demanded some bribe from me. Upon my refusal and subsequent...
You are an advocate. You
Yes,
are an
my
advocate.
Yes, my lord. I am seeking apology because this word I am using in open forum. In the year of 2020,
take us to the impugned order.
Yes, my lord.
Order page 67.
পেপার বুক কই আমাকে চাইনিজ তো পেপার বুক
এবার সবাইকে দিয়েছি যদি না পান দেয় আপনাকে
Page
67. Page 67, my lord. Single bench, learned single bench.
কাকে দিয়েছিলেন পেপার বুক
কমিশনকে দিয়েছি
এখান থেকে আসি
My lord, can I start my submission?
Page
67.
67.
Yes, my lord. This is the order. 15 January 2025.
Yes.
My lord.
Place it.
Yes, my lord. The President of the District Consumer Commission, Satan Sas, my lord, upon my refusal and subsequent representation...
Where you are reading? Where you are reading? Which page are you reading?
No, my lord, I'm submit. It is 67, my lord, order of the single bench.
Yes.
Yes.
Where you are reading? Single bench order. Read from paragraph 1.
Paragraph 1 থেকে পড়ুন পিটিশনার অ্যাপ্রোচ ওই 67ই আছে, ওইটা জোসেফ যেটা জানতে চাইছে। 67ই petitioner approach
The
that
petitioner approached the district consumer redressal forum with his complaint. He alleged
bias on the
bias on the part of the district forum during the pendency of the complaint case. The instant writ petition was filed seeking transfer of the complaint case from one commission to another. But by the time the writ petition could be considered, the district forum disposed of the complaint case. The petitioner is aggrieved by the order passed by the district forum, my lord. It has been submitted that the commission ought not to have proceed with the complaint case as the writ petition was pending disposal before this court. No order of any competent forum has been brought to the notice of this court staying the hands of the commission in proceeding with the complaint case. The complaint case was decided on merit and disposed of by the district forum. As the petitioner appears to be aggrieved by the order passed by the district forum, it will be open for him to approach the appellate forum for relief. If so, advise the writ petition stand disposal. My lord, the district forum bias, I want to free and fair trial. That's why I have filed a transfer petition before the state commission. State commission has disposed of my transfer application and rejected. Then thereafter, I went to the national commission. National commission said they have no statute to interfere the.
Go one by one. You preferred an app.
Yes, my lord.
By the writ petition in which the order was passed, what was your prayer in this writ petition?
Prayer.
Page 27.
Yes, my lord.
So
issue a writ of mandamus directing the respondent number 2, the registrar of the state consumer dispute redressal commission, West Bengal, to transfer the case being CC 79 of 2020 from Baraipur district consumer dispute redressal commission to Darjeeling district consumer commission or any other nearby commission for the interest of justice and free and fair trial of the case.
So this order, this writ petition was affirmed on November 2024.
Yes, my lord. Because
then what happened? Writ petition, you did not get any interim order.
No. Writ petition did not get. Yes, my lord.
Then you challenged. Then what was the order passed by the commission? Where is that order passed by the commission?
My lord, 14 March 2023.
How can it be?
14 March 23, page number 31 to 35, SCDRC, State Consumer Dispute Resolution Commission, dispose of my case 31.
21st August 2024. State
Yes.
Consumer.
21st August 2024. My transfer application rejected.
This was the transfer application rejected.
Yes, my lord.
Main
Then
matter?
During the pendency of the main complaint case before the district forum, then I filed a transfer application before the state commission. State commission dismissed my case. Then thereafter I went to the national commission.
Against this order of 21st
yes, my lord.
August.
Against this order.
So what did the national commission
Yes, my
say?
lord. Yes, my lord. National commission order page number 36 to 37 B, my lord, 36.
Page 36.
Yes, 36. My lord, question before. I'm ready. The question before the registered of whether the present complaint can be registered as first appeal or revision petition in the absence of any provision in the Consumer Protection Act 2019, providing for an appeal against the order passed by the State Commission under Section 48. Fact and briefed at that one, Sri Uttam Kumar Haldar had filed consumer complaint number 79 of 2020 before the District Consumer Commission, South 24 Pargana in the state of West Bengal, my lord. Second page, my lord. 37. He had moved the application before the Honorable State Commission seeking transfer of the consumer complaint from Baraipur District Consumer Commission to District Commission, Sialda. The said application was rejected by the Honorable State Commission. I had order dated 21st August 2024, holding that there is no sufficient ground for transferring the complaint. This is that their feeling aggravated. Sri Uttam Kumar Haldar has filed the present complaint in the name and style of first appeal. At the stage, attention of the Honorable Bench is invited to the observation made by the Honorable Commission in its order dated 8th of March 2024 in the matter of Anando Drive-In Developed Private Limited and Sanjay Kumar Singh and hereunder. My lord, next page, para number 9. In view of the above, the present completion is placed before the Honorable Bench with a diary number for kind perusal and direction. Submitted, please. The question is as to whether an appeal or revision would lie before this commission against the rejection of the transfer application by the State Commission in exercise of its power under Section 48 of the Consumer Protection Act 2019. There is no provision for appeal before the National Commission against an order of rejection of a transfer application under the Act. The Register has indicated that possibility of treating it as a revision in view of the legal provision as interpreted in the case of Rajesh Kudi versus Ram Singh and others in revision petition number such and such, my lord. Replying on the decision of the Bombay High Court in the case of such and such, my lord. And another decision of the Odisha High Court, read petition number 775 of 2015, Oriental Bank of Commerce versus Minarabha Das and others, decided on Ato. Against an order passed in a consumer dispute, which, my lord, next page, which is in a complaint, thus the power of division can be exercised only to that extent that not beyond the same in view of that revision would also not lie in so far as the rejection of the transfer application is concerned, as it is not a decision in a consumer dispute in a complaint, my lord.
Now,
and second, next para, my lord, this is not a case whether the provision of Section 62 of the Consumer Protection Act 2019 are attracted where the power of the Commission is to transfer the case from one state to another.
Now, ultimately,
NCDRC directed me to approach the High Court.
So you
Constitutional
filed
Court.
the High Court.
Yes, my lord. Then thereafter, I have filed the writ petition, but during the writ petition, I have submitted 3 applications before the District Commission, where the transfer application is pending, kindly not to pass any adverse order or any of them. My lord, kindly come to page number. Adjournment petition 172 to 179, my lord.
Disposed of the complaint case. Where is the order in the complaint case? Where is the final order in the complaint case?
Yes, yes, my lord. I think it's 69. Final order, my lord, 167 to 171. 167. 167, my lord. This is the final order. District Commission.
Have you challenged this?
Yes, my lord.
Before
Because
the National Commission?
because he has this order when passed for the purpose of
Have you challenged this order before the
yes,
commission?
my lord, only for preserve the limitation period. I have filed a appeal before the state commission. Yes, my lord.
Yes.
My question, during the pendency of the transfer application.
Take that point in appeal.
Yes, my lord, only for preserve the limitation period.
Your appeal has not yet been heard.
Yes, my lord.
Go to the appellate forum and say that my transfer application was not disposed of. Though the Supreme Court directed that I can agitate that issue before the. But how can we help you at this stage? You are coming up against us on an order of 15 January 2025. The complaint was finally disposed of.
Yes, my lord.
On 13th of December.
I know this is perverse because I did not appear when the in the proceeding because
then you should have taken immediate steps prior to disposal of the complaint. Had you taken immediate steps, because your writ petition was filed in November 2025.
yes, I mean dispose of this case December 13, 2025-24.
Exactly. So
Yes.
you should have immediate.
And during the pendency of the writ petition, this complaint case disposed of.
Right.
Yes.
So after the disposal of the main complaint, what will be decided in the writ petition? Because writ petition was taken up on 15 January 2025.
Yes, my lord, dispose of.
Your writ petition was filed in November 2020.
2024.
So November 24 to January 25, you did not take any steps.
Yes, my lord, I have taken all the steps. During the pendency of the writ petition, I have submitted 3 applications before the district commission.
Understand, right? Not about you ought to have moved the writ court that my final complaint will be disposed of. Kindly hear the writ petition.
No, my lord. Before this disposal of the writ petition, one order already passed by the single bench. Yes, my lord.
Where is that order?
Yes, my lord. My lord, 173. The petitioner is a practicing advocate. He filed a complaint before the District Consumer Dispute Redressal Commission at Baraipur on challenge of the deficiency in service demanded by the respondents 1 to 6 in the year of 2020. Petitioner sought for transfer of the said complaint on the ground of bias. My lord.
Please read the total order.
Okay. And as the prayer stood refused, the petitioner approached the state forum and thereafter went to the way to National Consumer Dispute Redressal Commission. By an order dated 29th October 2024, the National Consumer Dispute Redressal Commission opined that the petitioner cannot avail either the remedy of appeal or revision, and the only remedy of the complainant is to approach the Constitutional Court having jurisdiction in the matter to challenge the impugned order. In view of such direction, the petitioner is here before this court under Article 226 of the Constitution of India. My lord, second para number 4, the issue related to supply of goods car and deficiency of service on the part of the dealer in delivering the same on time. The petitioner obtained loan for purchasing the car. The bank has released the entire payment to the dealer, which the dealer admit to have received. The car, however, has not been delivered. The loan account of the petitioner has turned to NPA. The interest of the account is increasing day by day. The petitioner currently is not inclined to accept the car. Learned advocate.
Settlemented
চ্যালেঞ্জ করে
যখন merge হয়ে গেছে with the fine body, যেটা transfer এর একটা
Yes, my lord.
In that appeal, have you taken this point of transfer petition not being disposed of prior to taking up of the main matter?
Yes, yes, all the matter disclosed in the appeal. My fact, this
Mr. Haldar, try to understand my brother's question.
Yes, my lord.
Your appeal against the final disposal of your consumer forum case, that is 13 December 24.
Yes, my lord.
You have preferred a statutory appeal before the state commission.
Yes, my lord.
Is that appeal pending?
Yes, my lord, pending.
And have you taken the point of this transfer petition pending?
During the pendency of the transfer
taken that
petition,
point?
yes, the district commission dispose of.
Have you taken this point?
Yes, point I have taken in this point. But matter is another.
তারপরে ফাইনাল অর্ডার নিতে বললো যে তুমি ইয়ের কাছে অ্যাপিল ফাইল।
My lord, my matter is now another because the district consumer commission physically assaulted me, and I have the president of the district consumer commission physically assaulted me, and I have filed criminal case and just 1 minute, and also lost GD. Then
physically assaulted you?
Yes, my lord. I have kindly come to page number 43. Kindly page number 43. GD 43.
Well, unfortunately, no paper book has been submitted.
My lord,
only
I have
the application.
My lord, I have submitted to the Devar garage. Then thereafter, the Lord Council, this type of what is using, I have did not hand over. How is possible?
How can we help you, Mr. Haldar?
My lord,
you are not trying to understand what you are saying. You filed a district commission, you file a complaint.
Yes, my lord.
When it was being considered, you took a point that the officer is biased. You filed an application for transfer of the complaint case to another forum.
No, my lord, physically assaulted and was FIR against him. Then thereafter, further altercation, I want to avoid. That's why I filed a transfer petition. Not only that, the district consumer commission repeatedly passed biased order.
So the sequence is like this: that he first assaulted you, you filed a FIR, and then you filed the transfer petition.
Yes. Then thereafter, I have filed a transfer petition for avoiding further altercation.
When did you file the transfer application?
My lord, 2023. I filed a transfer application before the State Commission 14 March 2023 and rejected 21st August 2024.
Where is that order? 21st August.
Yes, my lord. Page number 31. My lord, then thereafter.
Please keep quiet.
Yes, my lord.
Peter against you. National Commission. Pending না রিপোর্টে পেন্ডিং ছিল তখন রিপোর্ট একটা ইন্টারিম অর্ডার যেটা হচ্ছে এইটা দেখে ফাইনাল কমপ্লিট করেছে The state commission.
State commission just passed one order for stay of this order, which passed by the district commission.
Stay order has
Stay
been
order.
given.
Yes, my lord.
Can
This
you
was
do us? Can you-
Yes, yes, my lord. I have submitted along page number. Yes, my lord. Page number 180, my lord.
Is it change order?
একটা চেক করুন কিন্তু তুমি অ্যাপিলেট করে কিন্তু বিলটা করবো ওয়ারেন্ট কেন করলো ব্যাংক তো ছিল ব্যাংকের প্রেজেন্সে অর্ডার তাহলে ব্যাংক ওখানে গিয়ে প্রসিড করলি কেন তুই ডিস্ট্রিক্ট ফোরাম হ্যাঁ ডিস্ট্রিক্ট ফোরামে প্রসিড করলি অর্ডারটা হচ্ছে তখন তো বলা উচিত ছিল তুমি অর্ডারটা 13 ডিসেম্বর ডিসেম্বরের মধ্যে কত পার্টিকুলার্স গুলো দাও কত আউটস্ট্যান্ডিং আছে ব্রেকআপটা 13 ডিসেম্বর কি অর্ডারটা নিয়ে নিলি ডিসমিস করে দিলি এটা
How much did you pay to them?
My lord, till today, 28 EMI already deducted from my bank account.
Any proceeding initiated under SARFAESI Act against you?
No, my lord. Actually, I have filed a civil case before the
And
second.
obtained a
Yes,
stay order?
yes, no. I am seeking stay order, but did not.
So
Allow.
in the SARFAESI, they have nothing.
No, my lord, this is not.
When did you, how much amount have you paid?
83,000 I have. Yes,
Where do we find that? How much loan did you take from them?
yes, my lord. 3,83,000 total.
Just a moment.
Yes, my lord.
3,83,000 was the total loan taken.
No, my lord. Total price of the car.
3 lakh টাকা লোন
And loan amount 3 lakhs. And the rest 83,000 I have paid to the dealer.
Wait. 3 lakhs was the card cost.
Loan amount, my lord.
Oh, loan price was 3 lakh 83.
8, my lord.
Loan amount was 3 lakh. 3 lakh.
Only. And rest.
When did you take this loan? When did you take this loan?
In the year of 2020, November first week. That.
Achha, very good. Now, how much money they have recovered from you? Against the loan, how much have you paid?
28 EMI, that is more or less 50% already paid.
Slightly more than 2 lakhs.
Sir, my lord.
So,
88.
what did you do with 3 lakhs loan?
ব্যাংক ডিরেক্ট টু দিয়ে দিয়েছে ডিভোর্স
It was paid directly to the what?
Yes, no. 83,000 directly cash paid. And the rest of amount, 80.
Please understand what my lord is asking. The 3 lakh was paid directly by the bank to the car company to divorce. The 3 lakh loan.
Yes, my lord.
82 you paid in cash to divorce again. So 3 lakh 82. That's the price of the car.
Yes. 83.
83.
Yes.
After that, the bank has deducted 28 installments of 6,062 each.
Yes.
So that's about 2 lakh 20 odd you have paid to the bank. How much is outstanding?
I do not have any idea what is how much outstanding because I did not get any of the car.
We are about 2 lakhs. তো আউটস্ট্যান্ডিং
আমি কি করব
যেটা দিয়েছি ইনস্টলমেন্ট দিয়েছেন তার সেটা তো ক্যালকুলেশন করলেই তো
তার ইন্টারেস্ট বাড়ছে সবকিছু বাড়ছে আমি কি করে বলবো এইভাবে ব্যাংক বলতে পারবো
Why did you not accept the car, Mr. Haldar? Because
lord,
it
for
came,
safety and security in the time of corona, but they did not deliver the car timely. That's why I rejected.
how much was
Then
the
I have given more time,
how much was the delay? You are saying that
more or less 15 to 20 days.
15 to 20 days.
Yes. Then thereafter they abused me, and also I have lost complaint. And police also said to them, deliver the car, but they intentionally did not deliver the car. That's why I rejected. And I want to desire, I will take the car from another dealer. But they instantly informed me.
Diwar garage, nobody appeared. Who is appearing for Diwar?
My lord, I submitted all the evidence service.
এখন অর্ডার সিটে দেখুন কে অ্যাপিয়ার করেছিল দেওয়ালের
Yes, yes, তারা অ্যাপিয়ার করেছিল। আগের ডেটে
না,
অ্যাপিয়ার করেছিল।
এতে
ওখানে করেনি, আপনি এই কেসে আগের ডেটে দেখুন অ্যাপিয়ার করেছে। His last appeal, which I have
that stay order.
Yes, my lord.
174.
Final order কি? ডিস্ট্রিক্ট কমিশন কি বললো? এটা ডিসমিস করে দিয়েছে, তাই তো?
Page number 180.
Page number
180, my lord. 180 and 181.
180.
Yes, my lord.
How can we help you, Mr. Haldar?
My lord.
How can we help you?
Yes, my lord.
We can do this much. We will direct the state commission to hear from you the allegation of bias which you made against the president. They will have to consider that and then dispose of your appeal.
Yes, my lord. My lord.
That much we can do.
Yes, my lord.
But you will neither get back your card, nor you will, now they will initiate surface proceedings against you.
My
You
lord.
have stopped payment EMI.
No, my lord.
You are still paying EMI.
They sent ECS to my bank account, but the insufficient balance. Then thereafter,
Now they will proceed against you. আবার বলে no.
Yes, my lord, because Surface Act not lie. Because this is the
that you obtained civil court granted a stay order.
No, my lord.
You did not challenge the surface proceedings before. You said no.
Actually, as per Surface Act, the civil court rejected my stay order. But Surface Act not lie under section 30.
Have you challenged that order of civil court? Huh? You are appearing in person. You know everything.
My lord.
When civil court rejected that prayer, did you come up in revision before the High Court? So they are now free. They will proceed against you under surface.
Mr. Haldar,
yes, my lord.
You don't want the car. You don't want the car. গাড়িটা চান না?
Do you want the car? No, my lord.
You don't want.
No, my.
Where is the vehicle?
Vehicles, I do not have any knowledge. Where are the vehicles?
গাড়িটা তো ওর। ওটা বেঁচে দিয়েছে দিয়েছে না কেন কি করে বেঁচে গাড়িটা তো রেজিস্ট্রেশন আছে তোর নাম
No, my lord, no registration. No registration done.
বন্ধ করিয়েছে আমি দেখলাম এখানে they have spent a lot of money registering the car in his favor গাড়িটা পিছিয়ে বাকি টাকাটা ব্যাংকে দিক ও কেন দেবে ये ব্যাংকের এগেন্সে সুট ফাইল করতে রিকভার যে টাকাটা দিয়েছে কি অবস্থা হয়েছে
Who is Diwar Garage? You are Diwar Garage, Mr.
Actually, my lord, last occasion their garage appeared in the chief. Yes, yes, my lord. This is 184, my lord. Ramendra Agarwal for the respondent number 3. He was appeared.
Page
And Mrs. Sonia Das.
Page 1.
184. Yes, my lord.
Only
I have already served the notice. I have filed this affidavit in service, my lord.
my lord, only submission on the part of me. Kindly supply me a copy of the paper book, my lord. Only stay application. I am appearing on behalf.
Paper.
No, my lord, just one.
File it in the department.
No.
So then he must get a copy, na?
I himself went to their office and submit.
Whose office?
Topsia Devar Garage.
No, I am not. I am appearing under the registered state consumer.
Yes, State Consumer Commission, I have filed, and receipt section, they also stamp it. Receipt. My lord, evidence service already filed. Receipt করেছে।
Don't you have an extra copy?
My lord, just one copy I have, my lord.
একটা আর কপি দিয়ে দাও
আবার কে? আপনি
কি করবো আমি কি করে?
You are appearing for whom?
Union of India.
Union of India মানে
Union of India এখানে কি কাজ
What will union do?
buy him a new car
State also has nothing. We will record your presence. First we have to get the Diwar. দেখি সার্চ করেছে দেখাও কোথায়
from ALK দরকার
আমাদের তো কোনো নেই
Did you serve upon the
State Commission? Yes, my lord.
Uttara, Diwar.
Yes, my lord.
Where do we get it? Served it on
2 times I have served.
সার্ভিসের কপি নেই
আছে বাবা থাকবে না
কোথায় সার্ভিস করেছে কবে করেছে
সব আছে ওখানটায়
বন্ধুরা ডেকে পাঠাবো আজকে Mr. Haldar,
yes, my lord.
Serve the advocate appearing for divorce. Let him come once.
Then
But
thereafter
don't have to
the
serve.
paper book want to make. Then thereafter
No, you have given paper book to Mr. Agarwal who appeared for Diwar.
yes, I have
Must have given.
yes, yes. After making the paper book, then thereafter I went to the Devar Garage office and by hand I have submitted.
Very good. Where is that receipt? You went to the office and gave.
Yes, my lord. I have.
So that is why they. কোথায় পাবো? Where did you start? Diwar Garage, এটা দেখাও তো।
লয়ারদের দিয়ে দিলে এগুলো ঝামেলাগুলো হয় না কমপ্লিকেটেড
ছুটে
স্যার
Yes, my lord. Managing Director, my lord. Managing Director of their garage. এটা নিয়ে নাও, এটা নিয়ে নাও।
Affidavit of service as filed, comma,
Yes, my lord.
Milord, may I
May I
mention item 16, Milord?
written argument,
আরে আর্গুমেন্টই শোনা হলো না
Milord, before your lordship rises, Milord, may I mention item 16, Milord? I am for the respondent number 6 to 8. I have got to leave for home, Milord, during recess for a family emergency. A senior member has fallen ill. Kindly, if your
I
lordship
am for the
makes
state,
it,
my lord.
the state
next
is also
monthly list. Next monthly list.
Milord,
Yes.
any day, Milord, instead of
Item number 16.
My lord, I'm for the petition in this matter. So
Eh,
item
All
16.
right, next monthly list.
grateful to your lord.
বাবু
My lord, before Mr. Mitra, my lord, starts making his submissions, my lord, may I say this? My lord, I am appearing on behalf of, my lord, the appellants in item number 62. And Mr. Joydeep Kaur, my lord, he is unwell. That is why, my lord, I am making this submission. My lord, he is appearing in Mr. Joydeep Kaur. He is unwell, so he could not come to court today. My lord, he is appearing in item number 70. My lord, on behalf of my lord, the appellant submissions have been made. We really do not want to, my lord, repeat those. So, my lord, kindly allow us to make, my lord, requisite submission, my lord, maybe for 5-10 minutes in reply.
So far as 34 is concerned, I have a different group. I will take for 10 minutes time.
Let us start with Mr.
Yes.
Mitra.
Oh, sorry to interrupt, my lord, this.
76. My lord, I am appearing in item number 76 in your lordship's list.
What is the appeal number, Mr. Mitra?
This is, my lord, mat number 966 of 2023.
Will you be placing from that paper book or from the 870?
I will not refer your lordship to the paper book excepting the judgment. In whichever paper book the judgment is there, my lord, I am not going to rely upon anything else but and my lord, the two rules I am going to, my entire submission will be on that.
নাম্বারটা কত বলবো? মিটিং 9.
Well, I shall give your lordship, first of all, certain figures, just to, my lord, apprise your lordship of the topography of the entire matter. My lord, altogether, the total vacancy was 42,949. My lord, 10% of this was reserved for para teachers.
42,949.
This is the total vacancy at the relevant time. And my lord, 10% of this, which comes to, my lord, 4,295, that was reserved for the para teachers. My lord, as per the breakup published by the board, 3,205 were appointed as para teachers in the vacancies. That means out of 4,295, 3,205 vacancies of the para teachers was filled up.
3,000?
3,205.
Yes.
The next thing is this, that out of these 3,205 para teachers, 239 were trained, that is qualified under DLED. And balance 2,966, my lord, they were trained in course of their appointment during the period of their
Are you for the para teachers?
I am for the para teachers. I am appearing for the para teachers. And my lord, my submission will be.
But your appointment has not been cancelled.
That is the point. Our appointment has been cancelled without considering my submissions, without considering, my lord, the position of these para teachers. This is a very unfortunate thing. I shall make my submissions on that at the end of it. And I will submit to you.
You are not parties to that. You are not parties to the writ petition.
No, nobody is party to it. The only persons parties, my lord, was a.
So 239 are trained and the remaining is?
Remaining balance, my lord, 2,966. They got trained.
2,906.
66. They got
66.
trained. And my lord, they all of them obtained DLED degree during their tenure as teacher.
So within the time, no, it was after the time specified.
There is no. I shall take your lordship to the rules. But I wish, my lord, the learned judge had taken the trouble of looking into the rules before, my lord, his lordship was pleased to pass the order.
No, for para teachers also the recruitment qualification was the same.
My lord,
Madhyamik, Uচ্চ Madhyamik marks, TET, and you are not required to appear in TET.
My lord, my lord, his requirement from me is appearing from the rules itself. So, my lord, what the learned judge has, my lord, very with the greatest of respect to the learned judge, I respectfully submit, my lord, that his lordship was not apprised of what the rules are, what rules should govern, and who are the persons who are directly affected by this. Well, my submission is this, that when so many, in the interest of so many persons are involved, then, my lord, perhaps the learned judge shouldn't have passed a sort of blanket order taking away the service employment of all these persons together.
No, have you been removed? No.
Yeah, I'm the order that has been passed, that, my lord, terminates my service. So, my lord, I am now subsisting by reason of your lordship's appellate court order. Otherwise, I would have been out on the street, my lord, holding dharna and all that. Thankfully, not yet.
So, Mr. Mitra, did you prefer any leave to appeal?
Yes. My lord, there are
before
966. Mat number 966. 175 persons, my lord, my client. I think, my lord, Mrs. Sanyal
you
is
were granted leave by which order?
By, I tell you, lordship.
Order of Justice Talukdar. Now, let us understand just Mr. Anindo Mitro's clients.
Yes.
They went straight to the Supreme Court.
But they were appealing not for the para teachers.
They preferred leave to appeal before division.
Yes.
So, Mr. Kollanmoy, Mr. Bandopadhyay's clients went direct to the Supreme Court. Yes, madam, please wait. We have not asked you. Will you please wait? See, Mr. How difficult to conduct hearing. Have we asked you anything, madam? Have we called upon you to answer anything? If Mr. Bandopadhyay's name is uttered, you will respond. You are very junior. We are treating you appropriately. Don't take us to that limit that we take some steps against you. So you take your seat and keep quiet and sit down. Over enthusiasm does not help you in practice. A senior counsel is arguing. I have put a question to him. And somebody from the door at the further starts hearing. When we ask for assistance, please give the assistance. Not in this manner. Yes, you also preferred leave to appeal before the...
আমাদের কোন অর্ডারে ই করেছিল, লিভ দিয়েছিল?
You will give us the page number of the leave to appeal order in respect of your clients as well as in respect of the persons for whom Mr. Bandyopadhyay was appealing. Now, nobody did directly go to Supreme Court. Everybody, you know, that 7th of July in the special leave petition order which was passed, that was passed by any independent application for leave to appeal, or everybody went to the appeal court, leave to appeal given?
না, ভুল বলছো।
That was not satisfied by the parties. They preferred the case 19th May, Selfie was 7th July.
ও আচ্ছা, 2023 এটা কি আমরা আমাদের? আর ইউ শিওর? আমরা গেছিলাম, ওটা আমার সাথে আবার
Yes, Mr.
Well, I stand corrected. Your Lordship was pleased to ask me whether we went to the Supreme Court or not. I said no. Well, I correct myself because
No,
I
you touched the division bench. You must have preferred a leave
no.
to
Well,
appeal.
what happened was this: I'm told that on 25th September 2023, my clients went to the Supreme Court, and when the Supreme Court sent us back to this honorable court. 25th September 2023.
You went directly to the Supreme Court.
Division bench
ডিভিশন বেঞ্চ বলেছিল সিঙ্গেল বেঞ্চে যাও, সেই অর্ডারটাকে চ্যালেঞ্জ করে আমরা সুপ্রিম কোর্টে গেছি।
Well, what happened was this: we came to the division bench first, and the appellate bench was pleased to direct us to go back to the trial court, the single bench. So against that, we went to the Supreme Court. We said that we don't want to go to the learned single judge. So against that, we went to the Supreme Court, and the Supreme Court said that you go with the division bench for this court. And that is, my lord, an order dated 25th September 2023. And my lord, after that order was passed, on the 15th September 2024, we preferred this appeal.
Now, please give us that order of
Yes.
25th
Well,
September.
this is a. Well, I'm sorry, but I've got only one copy. May I hand up to your lordship?
Doesn't
The division bench order is this: 15 June 2023. Then, my lord, Supreme Court order. 25th September 2023.
This is 19th.
এখানে আমাদের কজন রয়েছে প্যারা টিচার? 500 585
He ordered the against just we are clarifying
Lordship,
against this judgment of 12th May 2023.
Correct.
So far, the counsels who have argued, they were not parties to the same. We have heard Mr. First,
I think the Advocate General first.
We heard the board, then Mr. Bandyopadhyay, then Mr. Mitra.
Correct.
So, in respect of Mr. Bandyopadhyay and Mr. Mitra's client, they were parties before after this order was first order was passed by Justice Talukdar, no?
Yes.
In that you preferred leave to appeal, or that was this was an appeal preferred by the board?
This the main appeal has been preferred by the court. We have obtained leave, my lord. 589 para teachers have obtained leave of this honorable court on 15th September 2024 to prefer this appeal.
15th September order is with you.
Yes, 66 ম্যাট এটা আমরা প্রেফার
It's 25th September.
শুনে অর্ডার দিলেন, তার এগেইনস্ট আমরা সুপ্রিম কোর্ট গেলাম, সুপ্রিম কোর্ট থেকে রিভার্ট ব্যাক
করে আবার
ম্যাট্রিক্সটাই আমরা কনসিডার করেছি।
But have I been able to make clear, my lord? This is some amount of confusion is there because there have been movement to and fro.
No, that
So-
is why if we the judgment was 12th of May 2020.
Correct.
Against that, the appeal was preferred by the board. Only by the board.
Board, along with Malad, 2-3 groups, Malad preferred Malad leave to appeal before Justice Talukdar.
And they were not para teachers.
So there was any leave to appeal by the para teachers also on that date?
No, on that day, there was no appeal from the para teacher. After the order of Justice Talukdar, Malad interim order, just after the order, Malad, the next day, some of the candidate from the para teacher preferred an appeal, whereby the division bench directed them to go before the single judge. The first order by Justice Talukdar, when the appeal...
First order of Justice Talukdar was staying the appointment, but saying that the examination procedure will continue.
Absolutely.
Now, after that order, aggrieved by that, again one group went to Supreme Court.
Both
the board as well
as the other group.
Who were before Justice Talukdar.
Yes.
Now the Supreme Court said that no, we are staying the fresh appointment also. Now, did the para teachers add themselves or pray for leave to appeal subsequent to that? So where is the order of the Supreme Court was of 7th of September, na? That
July.
7th of July.
Main order.
Mr. Why don't you give us a handed over loose copies? I want a bundle of that so that we can maintain the track. If you can do so, otherwise.
I think that will be helpful.
Immediate Malad, I will hand over.
Yes.
Just I want to know there are 44 appeals, na? So till now we have here this is a board's appeal. He has argued. We have heard Mr. Mitra today. We will be hearing but no, there are many leave to appeal applications. We want to know what were the orders passed in this.
I'll do it.
Yes, Mr. Mitra.
Malad, if I may just give you lordship a short introduction, that para teachers are contractual teachers engaged in different government schools across the state. Malad, under Paschim Bongo Sarbo Shiksha Mission. And Malad, they are imparting education to students and they are discharging, my lord, at par with the assistant teachers, but at a much lower salary. So, my lord, the para teachers are appointed almost like, my lord, a sort of ancillary to the regular teachers for the purpose of education in the primary section. Now, my lord, as I told you, lordship, in the total vacancy, being, my lord, 42,949, under the rules, under the law, my lord, 10% has to be, my lord, kept vacant for the para teachers. And that was there, my lord, we came in. This appeal, which your lordship is hearing, 966 of 2024-23, my lord, that is an appeal by 585 para teachers.
Yes.
My lord, I will request your lordship, my lord, when they were, my lord, around second month, the two rules I shall refer your lordship to. My lord, kindly take, my lord, the 2nd March 2016 notification. As per this notification, 10% of the existing vacant posts shall be filled up by the para teachers. As
no paperwork in this? In your appeal, there is no paperwork? No.
আমাদের কোন পেপার ডিকশন ছিল না আমাদের এটা কি
Viral by dated over, it is there. Two files. All rules are there. The lordship will find all rules.
You are placing which rule, Mr. Mitra?
Yes, well, I shall. My lord, I have been told, my lord, that the stay application and, my lord, the memorandum of appeal on which, my lord, this leave has been granted, that is there before your lordship.
Your rules are annexed to that? Your
rules? No, my lord, not in my paper book.
So, which rule are you placing, Mr.
I am, my lord, 2nd March 2016. This is, my lord, West Bengal Primary School Teachers Recruitment
Yes.
Rules 2016.
Yes.
There are two sets of rules. Judge সাহেবের কাছে রয়েছে কেন দেখছি একবার দেখে নিন।
Yes, 2nd March 2016.
16. And this is known as West Bengal Primary School Teachers Recruitment Rules 2016.
Yes.
Now, my lord, kindly come to straight away first to Rule 6. Kindly come to Rule 6.
Yes.
I am not troubling your lordship with sub-rule 1 and sub-rule 2, these qualifications. Well, lord, kindly come to Rule 3, sub-rule 3.
Yes.
In the matter of appointment, priority shall be given to those eligible candidates who possess the minimum qualifications as specified by the National Council of Teachers Education and MHRD, and thereafter the eligible candidates with the relaxed qualification specified by MHRD may be considered. And if candidates with relaxed qualifications are considered as teachers, such teachers under the relaxed qualification norms shall be appointed with an undertaking to acquire the minimum qualifications specified in National Council of Teachers Education within a period of 2 years from the date of appointment. Now, my lord, I am not troubling your lordship. The other notes, kindly come to note 7, with which I am concerned.
This qualification you completed.
Yes. Kindly come to note 7.
Yes.
The state government may, by notification in the official gazette, earmark. Kindly, my lord, note the words earmark, because this will recur more than once. Earmark up to 10% of the total posts for the candidates belonging to para-teachers without disturbing the 100-point roster as notified by the state government from time to time, in such manner as may be mentioned in such notification. Then, my lord, the proviso, provided that the qualification of such categories of candidates shall be the same as mentioned in these rules. Then further proviso, provided further that notwithstanding anything contained in this rule, the upper age limit of the candidates to be appointed as teachers by earmarking 10% of the total posts shall be relaxable up to the period of service rendered by such candidate, subject to the maximum of 50 years, as on the 1st of January of the year of advertisement. Now, my lord, so this is, my lord, the rule under which 10% has been kept reserved for the para-teachers. And that is why I submitted to your lordship, out of this 42,000, 10% is 4,000 and odd. That is the number of para-teachers who are to be appointed. Now, my lord, kindly come to Rule 8, Sub-Rule 5. I shall take your lordship to other rules afterwards. Rule 5. This should be at page 6 of these rules. So far as Rule 8 is concerned, that is the procedure for selection. In this, my lord, Rule 5, Sub-Rule 5 is, the selection committee shall prepare separate council-wise panels as per the procedure below. Firstly, the selection committee shall segregate all eligible candidates applying for earmarked vacancies as mentioned in Note 7 to Rule 6 from other successful candidates. Therefore, my lord, kindly note A is
10%,
the selection committee, 10% will have to be earmarked. Then secondly, the selection committee shall prepare the following panels for the successful candidates who have applied for non-earmarked vacancies. I am not troubling your lordship with this. Kindly come to the Note 2 under B. Separate sets of panels for all selected candidates applying for earmarked posts as mentioned in Note 7 to Rule 6 shall be prepared in accordance with the procedure mentioned in Clause I to IV of Sub-Rule B. So, my lord, insofar as the para-teachers are concerned, 10% are to be separately treated, and separate sets of panels will have to be prepared for these earmarked posts, applying, my lord, the procedure mentioned in clause I to IV. Your lordship has got that? This is, my lord, note 2 or under subsection sub-rule 5 of rule 8.
So 8.5 is exclusively for para teachers.
8.5, not really. 8.5a is separately for para teachers, but B, 5b is in respect of all the rest. That means non-earmarked. That is why I showed to your lordship that insofar as 5b is concerned.
So non-earmarked vacancy, you are meaning to say that apart from para teachers.
Non-earmarked is apart from earmarked as the para teachers. And that is, my lord, as per the, I have shown to your lordship, this note 7 of rule 6. And that is why throughout your lordship will please to note that para teachers have been treated separately. That is note 2. Separate sets of panels for all selected candidates applying for earmarked posts. That is, my lord, para teachers posts. As mentioned in note 7 to rule 6 shall be prepared in accordance with procedure mentioned in clauses I to IV of sub-rule B.
So,
now, my lord,
so both are applicable.
Yes.
This formation of panel and segregation as appearing in respect of primary teachers are also for para teachers.
Yes. The same criteria will be applied in respect of both. Yes. In separate panel, my lord, 10% will have to be kept separate, and in respect of this 10% also the same thing will apply.
Para teacher appointment was not challenged.
But
Nobody's appointment was challenged.
They were not challenged, but my lord, unfortunately, we have been put into the same category and had been thrown out.
12th of May judgment, it says in paragraph 21, in such circumstances, appointment of all primary teachers is cancelled.
Yes, all primary teachers. So, my lord, in
You
that,
do
my
not
lord,
come within the primary teacher, then you are a para teacher.
no, my lord, we are primary teachers, my lord.
Against 10% earmarked vacancy.
Yes, we are
Your
primary teachers.
conditions of service are different. You are contractual.
I don't think so.
You will continue till 60 years of age.
50 years.
50 years.
No, I think it's extendable.
For primary teachers.
My lord, of the primary teachers, well, I have not been able to explain to your lordship. Of the primary teachers, 10% has been kept apart. And this 10% is only for the para teachers. So this 10%, one has to wait until it is fulfilled by the para teachers. My lord, non-para teachers will not be able to come into that category, if I have understood this system. So, my lord, insofar as we are concerned, now, my lord, we have been put into the same what should I say, same basket.
Any one of the writ petitioners was a para teacher?
No. 149 writ petitioners, none of them para teachers.
All primary teachers.
Yes, we came into the picture only in, my lord, at the appeal stage. After the order had been passed, and, my lord, we have been we found that we found one fine morning that we are on the street.
Yes.
We don't have any employment.
Yes.
Now, my lord, kindly take, your lordship is pleased to see the procedure mentioned in clauses I to I4 in sub-rule B.
Mr. Mitra, just interruption. Your selection has not been challenged, that you have not followed, that they said no aptitude test was there.
So that is what I wanted to show to your lordship. The learned judge went wrong there also.
No, you appeared in aptitude test.
No, I don't have to appear. My teaching experience is that is what, my lord,
we find that
this is, my lord, the rule of this is, I showed to your lordship 2nd March 2016 rule. Now, yes. Kindly take, my lord, 23rd September 2016 rules. Is it there before your lordship? Otherwise, I shall hand up to your lordship. 23rd September 2016. This is by way of amendment. of that March rule.
By which that Rule 7 was amended. That Note 7 was amended.
Rule 7, well, like, various amendments took place, including minor procedure for selection of Rule 8. And that is what is important.
Mr. Biswas, you just give us a that.
I'm just
আমার মনে হয় যে দুটো আলাদা দিয়ে দাও জসবকে দিয়ে I think it will be easier for your lordship if these rules should be kept separate.
আমাদের ব্যাগ থেকে বাক্য
Acha, Mr. 2nd of March was the advertisement. Second rule. Advertisement was September 19.
September 2016. 26 September 2016.
And my lord, by that time, 23rd September 2016, my lord, amendment has come into existence.
Amended.
This is very important. My lord, before your lordship goes into the amendment, kindly, my lord, come to rule of that March rules, Rule 8, Sub Rule 3.
My lord, your lordship will find, my lord, in the paper, this spiral binding, my lord, the index was also there, my lord. Your lordship will find, my lord,
September rule টা কোথায় আছে কত পাতায়
my lord,
এটা তো সেকেন্ড ভলিউমটা দিয়েছে এটাই দেখাচ্ছে হচ্ছে already tell us tell us we will go into that otherwise
kindly come back once more to the Rule 8.
Rule 8.
Rule 8, Sub Rule 3 of the March rule, the earlier rule.
Rule 8 you showed us just now. No, Rule 8, procedure for selection.
Procedure for selection. Procedure for selection. Kindly come to Sub Rule 3. Academic qualifications, training, performance in the TET, extracurricular activities, and performance in viva voce test or interview and aptitude test shall be computed in the manner as mentioned in the table A below. And here, my lord, your lordship has seen there is a table like this, and there your lordship sees extracurricular activities 5, viva voce or interview 5, aptitude test 5. Your lordship has got that. Now your lordship take the new rule, the subsequent rule, amendment of 2017, of September 2016.
So amendment was subsequent to advertisement.
No, it is before advertisement.
Advertisement was
On 26 September. 26 September. And this is 23rd September.
Yes, sir.
Your board appeal, take your paper book. We were shown this.
Yes, ma'am.
এটা কোনটা? Just. In your paper, page 100.
My lord, 120. 120 is the
111 is the recruitment rule.
And my lord, 120, your lordship. 26 September, your lordship will find
at
my
the
lord,
left-hand side top.
Left-hand side top.
26 September.
2016.
Acha, this amendment came prior to that.
Yes, 23rd September, 3 days prior to that.
This amendment is not in your paper book, 23rd September. Yes.
This was not before the learned trial judge, and he didn't have the occasion to consider this.
So,
my lord, kindly take this. My lord, your lordship got the notification.
Notification, which one? 26 September?
Of 23rd September, there is a notification, and thereafter the rules.
Yes, 23rd.
Yes, my lord, kindly see, my lord, the second paragraph of this.
Oh, where is the rule after amendment or next?
My lord, this is just before this notification is prior. There are two notifications of 23rd September. One notification is, my lord,
656, 657.
My lord, this is that kindly come to the second paragraph. This particular notification is specifically, my lord, for the purpose of protecting the interests of the para teachers. Kindly see second sentence. Now, therefore, the governor is pleased hereby to direct that during the forthcoming recruitment of teachers for primary schools, 10% of the existing vacant posts shall be filled.
657.
657. 657. 657. I am placing this first, and then, my lord, I am coming to 656. This is notification dated number 657 of the same date. Second paragraph is, now therefore the governor is pleased hereby to direct that during the forthcoming recruitment of teachers for primary schools, 10% of the existing vacant posts shall be filled up by the para-teachers serving at present at various primary schools in the state. Then, my lord, kindly come to the penultimate paragraph on this page. The governor is further pleased to direct that the Commissioner of School Education, West Bengal, shall earmark, and this is the earmark, the vacancies for the para-teachers while compiling vacancies as per sub-rule 2 of rule 4 of the said rules. Now, my lord, then your lordship will please to come to the notification of the same date, notification number 656. And this notification is by way of amendment. Amending, my lord, the earlier rule of, my lord, March. My lord, I don't want to trouble your lordship. Kindly come to, a few of these amendments will be required. Kindly come to the second page of this. Rule 7, which I just now placed before lordship, that has been amended in this notification.
Yes.
Kindly come to, first your lordship kindly comes to sub-rule 4 in the amendment. For sub-rule 3, my lord, kindly see sub-rule 3 I just now placed before lordship.
That is rule 7. Rule 7.
Rules, this thing, my lord, kindly see. Rule 8. Kindly come, first of all, come to rule 8. I come to rule 7 afterwards. In rule 8, that is, my lord, in the notification 4, paragraph 4.
So in omission of the chart, it
Yes.
was placed academic qualification, training, performance in TET, extracurricular, viva voce, or interview and aptitude, or teaching.
And 555. Now, my lord, this has been replaced by, my lord, this amendment of 4, sub-rule 4 in rule 8. In sub-rule 3, substitute the following sub-rule. Academic qualification, training, performance in TET, extracurricular activities, viva voce, or interview, and aptitude test, or, this is important, this has come in, or teaching experience in case of para-teachers. So aptitude test is no longer necessary for a para-teacher. And this is where the learned judge went wrong.
No, it is either or.
No.
Either it can be aptitude.
No. Well,
or
may I read it again? Interview and aptitude test, or teaching experience in case of para-teachers. It is aptitude test or teaching experience for the para-teachers. That means aptitude test for non-para-teachers. But so far as para-teachers is concerned, it is teaching experience.
And in the next clause, that aptitude test
Yes.
is omitted.
Your lordship sees this. In the amendment, serial number 7, their aptitude test A, B, teaching experience of para-teacher. So, my lord, really, my lord, if your lordship reads this whole thing together.
Come to the next one in sub-rule 3. In serial number 7 of table A, for the words, letters, figures, and brackets, aptitude test 5 marks, substitute the words, letters, figures.
Aptitude test, then B, teaching experience of para-teachers.
So, in respect of para-teachers, there was
only teaching experience, no aptitude test. This is made clear. The sentence in subparagraph 3 has been made clear in this box. So far as para-teachers is concerned, teaching experience only.
Yes.
So once my lord teaching, then kindly read this along with the next page, note 5. This the learned judge did not consider at all.
Note 5, yes.
No, sorry, note 6 on the next page. Note 6, marks of maximum 5 marks in serial number 7B of table A of this rule shall be awarded to para-teacher candidates in the following manner. Teaching experience, 5. So out of 10, 5 is teaching experience. Yes.
In respect of para teacher, there will be everything will be same, even except substitution of aptitude by teaching experience. This is your argument.
Correct. And my lord,
Trial judge did not consider
at all.
Very good.
My lord, this is one thing. Second thing is, kindly note, experience above 10 years, one gets 5 out of 5. This is the first one. Why I am saying so, now your lordship takes the impugned judgment. Kindly, my lord, take. Lordship will be pleased to come to straight away to paragraph. Your lordship will please to come to paragraph 14. Page 11, internal page 11, paragraph 14. Well, I am just demonstrating that these facts should have been brought before the court. Well, paragraph 14.
Just one.
Well,
in the writ petition, there was no averment as regards para teachers, subject to correction.
Correct.
No prayer for para teacher. In the judgment, 36,000, later 32,000 cancelled. What is appointment of 36,000 more or less candidates who were untrained at the time of recruitment 2016? Conducted by the post in the post of primary teachers be cancelled.
Well, I am not the primary teachers. Right? Of the primary teacher, there are 2 categories. Para teachers and non
definition of primary teacher in the
lordship kindly sees the notification, it will be clear. Kindly take the notification, it itself will say.
No, in the rule primary teacher is defined. Primary teacher defined.
Teacher the selection process
No.
Yes, Mr. Rathod, primary teacher defined.
Your lordship sees this?
Because of 2 condition they are coming. Because of number 32,000 and untrained primary teacher. That is why the para teachers, the group is coming.
Why a group is coming? How?
Because untrained primary teacher, number 1, and second is 32,000. That is why they are coming within the zone of.
No, as it is said 32,000, you are thinking that para teacher is included.
Yes.
That is your appreciation of the order.
That is their apprehension.
No, but where from did Mr. Mitro, you were under this phobia that your appointment has also gone?
Because that they are para teacher, they are primary teacher.
Show us the definition of primary teacher. Head teacher, primary.
Well, kindly see the notification. It is applicable. Kindly see the notification. What is the notification? It is the West Bengal Primary School Teachers Recruitment Rules.
Where you are reading?
Well, this is the 2nd March 2016 notification. Whereas the draft notification to frame the West Bengal Primary School Teachers Recruitment Rules to 2016, published as required. And in this, my lord, the para teachers are also included. They are also primary teachers. And this particular rules are applicable.
Where from do we get it? They are primary teachers.
Well, this is
para teachers.
Well, may I come back to it? Just well, kindly see this notification, 2nd March, your lordship has got it. It is West Bengal Primary School Teachers Recruitment Rules. In this, my lord, kindly come to rule. I just now placed before lordship. Kindly come to rule 6. In rule 6, my lord, sub rule 3,
That is for
Kindly
training.
see note 7. This is specifically saying, provided further that notwithstanding anything contained in this rule, the upper age limit of the candidates to be approved, the state government may, by notification in the official gazette, earmark up to 10% of the total posts for the candidates belonging to para teachers without disturbing 100-point roster. So, my lord, what is happening is this: in the matter of selection,
This means the total post of candidates
yes,
belonging to para teachers.
candidates for primary teachers, for the post of primary teachers.
Wait,
This,
that line is not there.
no, but
Mr.
this is the rule. These rules are only for primary teachers. These are rules, my lord, West Bengal rules for teachers, primary school teachers.
Now kindly come to the definition of teacher. Rule 2O.
Rule 2.4.
Teacher means a person who holds a teaching post in primary school or in a junior basis on a regular and whole-time basis and is paid wholly or partly from the funds or control of the state in education.
Right, right.
You do not come within 2O.
Well, I wish I could. I did not.
That is, we are
I
asking,
wish I did not. But, my lord, it seems, my lord,
very good that under the same notification.
and this has also been made clear. This has also been made clear by the subsequent amendment. Kindly come to the amendment. The opening words. Notification 657. Bosho. Number 657. Whereas in terms of note 7, after sub rule 3 of rule 6 of the West Bengal Primary School Teachers Recruitment Rules 2016.
Where you are reading?
My lord, this is, my lord, the amendment notification of 23rd September, number 657. 657, not the 656. That is there, my lord, in front. The first page. Your lordship can mark it, my lord. 657 is a short notification, just one page.
Yes, yes.
This itself make it clear.
Yes.
Second paragraph, see. Now, therefore, the governor is pleased hereby. Well, kindly, let me read this. Whereas in terms of note 7, after sub rule 3 of rule 6 of the West Bengal Primary School Teachers Recruitment Rules 2016, hereinafter referred to as the said rules, it has been specified that the state government may, by notification, earmark up to 10% of the vacant posts for the candidates belonging to para teachers, vacant posts of primary teachers, belonging to para teachers without disturbing the 100-point roster as notified by the state government from time to time. In such manner may be mentioned in such notification to provide adequate representation of the para teachers. This is the notification. September notification was brought into existence for the purpose of protection or for the purpose of, my lord, for the purpose of laying down that 10% of the posts shall be filled up by the para teachers. So these are primary teachers. 10% of the primary teachers' posts will be filled up by. This is what is being protected by this notification. And there, my lord, your lordship has been pleased to see that para teachers, insofar as para teachers are concerned, the teaching experience is required. Aptitude test is not required. This is the alternative to this. For non-para teachers, aptitude test, but teaching experience in case of para teachers. Now, my lord, keeping this in mind, and I am showing your lordship, my lord, that insofar as teaching experience is concerned, note 6 of the September 2016 notification has specifically said that experience above 10 years, 5 marks, experience above 8 years, below 10 years is 4, experience above 6 years and below 8 years is 3, experience above 4 years and below 6 years is 2, and experience below 4 years is 1. That is how the marks is to be given. Now, keeping this in mind, kindly come to page 11. This is where, my lord, the learned judge went wrong, because, my lord, he did not take note of this, because it was not pointed out to his lordship. Paragraph 14. After holding that there had been a large-scale corruption in the earlier paragraphs, extraneous factors, etc., the court had said this in para 14. Now I give example of a candidate before giving a table prepared from the document on record. That is page 121 booklet. This candidate has got 2.866 in TET out of 5, 1.462 in secondary out of 5, 3.050 in higher secondary out of 10, totaling 7.378. This is not in respect of any of, my lord, the persons, my lord, for whom I am appearing, but has awarded 9.50 marks in interview and aptitude test. Aptitude test was not taken out of 10, whose total score became 16.878 and thus became eligible for appointment as a primary school teacher. Huge number of such absurd awarding of marks has come to light through the said booklet prepared from the particulars published by the board. Now, pausing here for a moment, a list has been given. My lord, none of these are para teachers, excepting, this is what I wanted to show to your lordship, page 12, 1, 2, 3, 4, 5, 6, sixth one from the bottom of this list. This is the only candidate, only person, my lord, who is a para teacher whose example has been given, and that too wrongly.
Which one? Six.
My lord, Sujan Kumar Bishas, sixth from the bottom. He is the only para teacher in this entire list. My lord, Mrs. Mitra has got that in the entire list, my lord, 6-1 from the bottom.
Sujan.
And my lord, this has been said to be an absurd giving of marks. Sujan Kumar Bishas, in the, my lord, TET MP high secondary, not a bad number, 10.333. My lord, almost toward the top. And my lord, so far as this interview marks is concerned, 9.50. Now, out of 9.50, your lordship has been pleased to see 5 marks is for teaching experience. And that one, 5 marks for teaching experience, my lord, out of that 5 out of 5, if it is more than 10 years. This gentleman, my lord, has 14 years teaching experience. This Sujan Kumar Bishas has 10 years of...
There is no possibility towards any other marking because it was specified. 5 years experience this much, 10 years this much.
So, my lord,
so aptitudes variation of marks does not apply in your case.
This has not been taken note of by the learned judge. So, my lord, the judgment went wrong in this. My lord, really, I submit to your lordship that this is the whole story. And my lord, my submission is this, that perhaps if the learned judge had taken note of these particular provisions for the para teachers, perhaps this error would not have cropped in. The error is, my lord, glaring error. Because in
Mr. Mitro, the relaxation granted by MHRD was for 2 years. By the memo, the other point which is being taken as regards training.
Yes.
239 out of 4295 were trained, para teacher. Remaining were untrained. At the beginning, you said that they have completed the training.
Yes.
Now, they have completed the training after the
after appointment.
No, but how can that be done? Relaxation was only for 6 months.
Lordship, kindly, my lord, again take that rules. What happens is this, so far as trained candidates are concerned, they are to be given preference. It is not that untrained candidates cannot be appointed. There, my lord, the learned judge went wrong. Kindly, my lord, take this. Kindly, my lord, come to, my lord, clause. Yes. Kindly come to
yes, that is there.
Proviso.
It will be given to the trained person.
Yes, proviso to rule 7, rule 8, sub rule 6, proviso. Or rather, I should say sub rule 7. Sub rule 7 of rule 8 at page 7 of these rules.
No, that we have seen. No, Mr. Ratul, where is that memo of the government that 2 years in your 870? Just one moment, Mr. That 2 years you have to complete that government memo.
মালাড না ওইটা নয় জজ সাহেব বলছেন 2 বছরের মধ্যে কমপ্লিট করতে হবে
That government memo.
I'm just
to become the trained candidate. To become the trained candidate. ওর বাদ করে দাও। But I shall make my submissions on this specific on this point. Kindly, my lord, I will request your lordship, my lord, kindly. That is why I say my entire submission will be on the rules, nothing but the rules. If your lordship comes to rule 8 of the March rules, procedure for selection, your lordship has got that. Kindly, my lord, come to.
Yes.
This will necessary.
I have seen that.
No, your lordship has not seen one very important thing. The procedure for selection, rule 8. That is at page 5. It's a longish rule. I am not troubling your lordship with this. Kindly, my lord, come to page 7 of that. Sub-rule 7 is about 10 lines from the top. Your lordship has got that?
Yeah.
While preparing, that's how it's. I think your lordship should be having, my lord, these rules separately. I think that will be easier for your lordship. Otherwise, one rule here, another rule there.
বলে দিই স্যার ওইটা স্যার যেটা জজ স্যার জানতে
হ্যাঁ এটা বলুন
Page 79 my lord.
এক second. Yes, finish it off, Mr.
My lord, kindly come to
7.
rule 8, sub-rule 7 at page 7.
Yes, while preparing the panels.
Yes, while preparing the panel, this is one on the emphasis was given. While preparing the panels mentioned in sub-rule 5 and sub-rule 6 above, the selection committee shall first, note the words first, divide all the candidates who will be found eligible after the interview into 2 categories, trained and untrained. And thereafter, 2 separate sets of panels for each category shall be prepared, one for the trained candidates and the other for the untrained candidate. Then, notwithstanding anything contained in any of these rules, the empaneled trained candidate shall be absorbed first against the sanctioned vacancies, and thereafter, the untrained empaneled candidate shall be absorbed against the remaining vacancies. It is not that the untrained candidates are totally excluded. You first of all absorb the trained candidate, and then you go for that untrained candidate. So, my lord, if there is an untrained candidate who had been absorbed after the trained candidates have been absorbed, then, my lord, untrained candidate can, my lord, get trained during the in course of their service. Nothing wrong in that, and become trained candidate. My lord, in the matter of appointment, I submit to your lordship, it does not make any difference. It makes difference in the sense that trained candidates will have the first preference. First of all, the vacant posts are to be filled up by the trained candidates. If there are sufficient vacant posts which are not filled up by the trained candidates, then the untrained candidates can come in also.
No, Mr. Mitra, that was not our. Please come to rule 6, sub-rule 3.
Rule 6, sub-rule 3.
59.
Our spiral binding, my lord, just hand over your lordship, my lord.
No, no, paper book ei to ache. 873 paper book.
6, sub-rule 3. Yeah. Yeah.
In case of, in the matter of
appointment, this is the one. Priority shall be given to eligible candidates who possess the minimum qualifications as specified in the National Council for Teacher Education and MHRD, and thereafter the eligible candidates with the relaxed qualifications specified by MHRD may be considered. And if candidates with relaxed qualification are considered as teachers, such teachers under the relaxed qualification norms shall be appointed with the undertaking to acquire the minimum qualification specified in the National Council of Teachers Education within a period of 2 years. But each of my candidates, each of the persons I am appearing for, they within 2 years after their appointment, they got their training for this particular course. Now, my lord, this is something I submit to your lordship. Forget about what I am saying. I say that when you are determining the future of a person who has been appointed and coming to the conclusion that they should not have been appointed, in my very respectful submission, each candidate was entitled to have his worth decided by the court. If the court didn't have the time, then the court shouldn't have accepted the money, the matter. After all, my lord, this is no child's play. These persons have been working, and suddenly one fine morning they find they're on the street. The court has not made it clear that this particular judgment will not be applicable in respect of para teachers. So what is the position then? We are still in the dark. Are we covered by the judgment, or are we not? The question that has fallen from your lordship, what is troubling your lordship, the suspicion, well, that suspicion is in my mind also. Well, this is my short submission before your lordship. I am submitting to your lordship, the court should have been much more introspective, much more careful in the matter. It should not have been done in this way.
No,
You
Mr.
give a
Mitro,
notice to this
you
person, put
have
somebody in the box, ask questions.
You have accepted it, Mr. Mitro.
What have I accepted?
When the leave to appeal was preferred, you ought to have taken the specific ground.
I have taken the specific ground. I have taken all these grounds in my grounds of appeal. What I am submitting to your lordship, it is not from my brainwave. This is what they have said. I am, my lord, only expressing to your lordship. Nothing more, nothing less.
If you are wrong, you are saying that I in fact do not come within the contours of this judgment.
Yes.
So if that is your prayer, that ground ought to have been highlighted in special leave in your leave to appeal. That why you are bringing me within this.
My lord, your lordship kindly sees my
subject to correction. That ground is not there.
Your lordship will
that
be.
I do not come within that. I do not come within at all those 32,000 teachers whom you have said to be cancelled.
My lord, let me check up. Maybe your lordship is right.
Your junior will check up, Mr. Mitro. You come to any other point if you have.
Well, they cannot ground that. My lord, this I submitted. This is one. Last thing, my lord, I submit insofar as the rules are concerned. The learned judge has come to the conclusion. Lordship will kindly come to that particular paragraph. Yes, selection committee টা কোথায় আছে? Paragraph 7. না কোন প্যারাগ্রাফে বলেছেন? 16. Yes, well, there is one other thing I just want to touch with lordship. Paragraph 16 of the judgment, deputy judgment.
Amendment was not taken into consideration.
Yes.
That is that he has argued.
So, my lord, I am not going to argue that. My lord, I just wind up my submission by saying this. Paragraph 17 is in my very respectful submission. Kindly do not take me amiss. If I am a bit, I shouldn't say, if I am a bit outspoken on this, your lordship, my lord, with your lordship's kindness, kindly excuse me. Paragraph 17. From the gross illegality in selection procedure in the recruitment exercise of 2016 conducted by the board, it is clear that the board and its officials, including its former president, who is now in custody after arrest by Enforcement Directorate for transaction of huge money in the recruitment procedure, conducted the whole affair like affair of a local club, and now it is gradually coming to light by investigation of Enforcement Directorate that jobs of primary school teachers were actually sold to some candidates who had the money to purchase employment. A corruption of this magnitude was never known in the state of West Bengal. The former education minister, the former president of the board, and a number of middlemen through whom the jobs were sold like a commodity are now behind the bars, and the CBI and ED investigation is being continued now in full swing. Then, my lord, kindly come to the next paragraph. It is a matter to be noted that board in its affidavit in opposition, while dealing with all pleadings of the petitioners, instead of addressing the allegation of corruption and illegalities in the recruitment process, raised some niceties of law and some principles of law. But however nice or however laudable these principles may be, this court, as a court of justice, will fail to deliver justice, knowing fully well that sense of justice is much above the sense of law. If the writ application is thrown out on such niceties of law, as this will mean that the name of preserving the law, the corruption would be protected, which a constitutional court can never do, keeping in mind the soul of our constitution and the constitutional conscience. I must say that in this recruitment scam, stinking rats are being smelled. My lord, these are very strong language the learned judge has used. But what has been said here, I am criticizing these particular observations. It has nothing to do with the matter before the court. The court completely went outside it. I should say the court went out of control by making this observation. And an observation on the basis, mainly on the basis of media reports. The court should not have done that. When, my lord, the court is deciding the fate of these persons as to whether they should be kept or they should be not, it is absolutely necessary that, my lord, the grain should have been, my lord, separated from the chaff. This was not done. A few stray examples were taken and some persons were put in the box, and, my lord, on the basis of their evidence, the fate of 40,000 people had been decided. My lord, before I conclude, I would like to place before your lordship a judgment of Lord Denning. This is very instructive. I would request your lordship look in. I should tell your lordship what happened. In this particular case, which was before the Court of Appeal in London, the learned judge was a very, very erudite judge. He might not cross-examine the witness more than the counsel. So, my lord, according to the appellant, there was a miscarriage of justice. He went up in appeal. And see, my lord, what Lord Denning has said. Quoting from a judgment of the master of the rolls, Green. And, my lord, I thought that perhaps I should bring it to your lordship's notice. It is instructive for all of us. And, my lord, it is also should be, my lord, something which your lordship should take note of. This is, my lord, Jones versus National Coal Board, reported in 1957 to Queen's Bench, page 55. I thought that this is very topical in view of, my lord, what is happening now all over. This was a case of trial. Factually, it is different. Here, my lord, it was a case of trial, and the learned judge had come into the arena of dispute and started questions in cross-examination of the witness, which, my lord, had not been looked upon with great favor by the appeal court. My lord, kindly come to page 6. I will not trouble your lordship with the entirety of the judgment. I am just indicating to your lordship what had transpired in that. But the observations of the court are quite, my lord, instructive. Page 6. There are 8 pages. Your lordship has seen the.
Yes.
Kindly come to the second paragraph on that page. Nevertheless, your lordship has got.
Yes.
Page 6 of 8.
We are quite clear.
Yeah. Nevertheless, second paragraph. Nevertheless, we are quite clear. Yes. That the interventions taken together were far more than they should have been. In the system of trial which we have evolved in this country, the judge sits to hear and determine issues raised by the parties, not to conduct an investigation or examination on behalf of the society at large. As happens, society at large, as happens we believe in some foreign countries. I hope it was not meant, India was not included in that. Even in England, however, a judge is not a mere umpire to answer questions. How is that? His object above all is to find out the truth and to do justice according to law. And in the daily pursuit of it, the advocate plays an honorable and necessary role. Was it not Lord Eldon, Lord Chancellor, who said in a notable passage that, then quote, truth is best discovered by powerful statement on both sides of the question. This is very important. Truth is best discovered by powerful statements on both sides of the question. Ex parte Lloyd. And Lord Green, Master of the Rolls, I was talking about this, who explains that justice is best done by a judge who holds the balance between the contending parties without himself taking a part in the disputations. If a judge, and said Lord Green, should himself conduct the examination of witnesses, then quote, he, so to speak, descends into the arena and is liable to have his vision clouded by the dust of conflict. Then, my lord, kindly come to about 10 lines from the bottom. My lord, the sentence starts with the after, my lord, Batman and Harris has been quoted. Then, my lord, the judge's part in all this. Your lordship has got that?
Yes.
The judge's part in all this is to hearken to the evidence, only himself asking questions of witnesses when it is necessary to clear up any point that has been overlooked or left obscure, to see that the advocates behave themselves seemingly and keep to the rules laid down by the law, to exclude the irrelevancies and discourage repetition, to make sure by wise intervention that he follows the points that the advocates are making and can assess the worth, and at the end make up his mind where the truth lies. If he goes beyond this, he drops the mantle of a judge and assumes the role of an advocate, and the change does not become him well. Lord Chancellor Bacon spoke right when he said that patience and gravity of hearing is an essential part of justice, and an over-speaking judge is no well-tuned symbol. Unquote. Such are our standards. They are set so high that we cannot hope to attain them all the time. In the very pursuit of justice, our keenness may outrun our sureness, and we may trip and fall. That is what has happened here. A judge of acute perception, acknowledged learning, and actuated by the best of motives, has nevertheless himself intervened so much in the conduct of the case that one of the parties, nay, each of them, has come away complaining that he was not able properly to put his case. And these complaints are, we think, justified. My lord, very loud and clear the judgment has been said. How a judge should behave, my lord, in a court of law. My lord, I cannot put my case higher than this. I will submit to your lordship that in view of paragraph 16, the learned judges, this judgment should not be sustained. The learned judge was influenced by outside consideration, which were not relevant, not germane to the issue. Well, I respectfully submit to your lordship that the order cannot be sustained. These are my respectful submissions.
Thank you.
So far, my lord, I am concerned, my lord, I have also an appeal in favor of the para teachers. That's my lord.
Anything to add, Mr.?
My lord, I have prepared a very 3 pages notes if your lordships consider that for the para teachers. And just to keep up to.
You are in which matter, Mr.?
My lord, mat number 1547. So that's what.
Mat
number 1547 of 2023, item number 58.
2023.
Item number 58.
1547 of 2023.
Serial number. Malad, just Malad, I place it, your lordships, this written notes, then your lordships.
Yes.
Para teacher. No, just the appellants.
Mr. Sannal, if you can tell us the points which have been left out so that we can.
I don't think left out only your losses. If your losses have any confusion regarding how the para teachers come into the picture of this. That's the only thing I have to clarify. Your losses I just place it. I think your losses get.
এটা ওইটার সাথে রাখো তাহলে এটা না ওই ম্যাট 966 এর সাথে জয়ন্ত মিত্র যেটা হ্যাঁ ঠিক আছে না না ওটা দিতে হবে তুমি আমাকে
The appellants applied for recruitment for recruitment para teacher against 10% earmarked vacancies of para teachers. This is wrong for recruitment, not para teachers, your lordships. For recruitment against 10% vacancies, 4295. Now 4295 means total vacancies 42,000 of para teachers in the recruitment process of 2016, as they all had been working as para teacher in primary schools. But up to 2010, para teachers were recruited and they had been continuing, as your losses, my learned senior friends, submitted on the contractual basis. Now, by virtue of the amendment of the rules, against 10% vacancies were earmarked for those para teachers for recruitment.
No, that is why I was saying that it is contractual, but you said no.
Not contractual, para teachers were contractual, but when I got appointment as primary teachers, that's not contractual. That's para teacher, primary teachers.
All right, that's you have said that it is included within those.
And that's included in those. That's your losses will get it. All the appellants were selected and appointed as primary teachers against 10% earmarked vacancies as para teachers in the year 2017. Total, my lord, your losses, this data have been supplied to your losses by Justice.
Mr. Sannal, tell us if the primary teacher and para teacher is the same.
No, not same.
10% is being cut off from the total vacancy of primary teachers.
Exactly.
If we proceed on that analogy, then how can you say a para teacher is same as primary teacher when your evaluation is different admittedly
But
from
I'm
primary?
not saying para teachers, same teachers. My lord, for
No, your argument was we come within the fold. Why did you prefer leave to appeal? Because you thought by virtue of this judgment we will be affected. Because why? Because from the total 100 vacancies, say 10 vacancies I have been given. Just we are asking you
Yes,
this.
yes, certainly.
Why do you consider yourself to be identical to those persons indicated in paragraph
My lord,
21
I tell
of
you,
the
lord,
judgment?
I'm giving one or two.
Judgment does not apply to your case then.
My lord, this is then your losses. The clarification is needed from your lordships. I tell your lordships why. 42,000 and odd vacancies.
Right, you are right. 42 out of 10%, you are taking 10% primary teacher vacancy for para teacher.
Well, that's God. But total vacancy 42,000, including para teachers. Vacancies. Now 10,000 odd for trained. Trained have been kept outside the Malad judgment. Then remains 32,000 and odd. Malad learned single judge was 32,000. Then figure has to be corrected. It has to be 28,000 and odd. We accept. Whenever the learned judge uttered that 32,000, without specifying this excludes Malad 10% para teachers, and it becomes 28,000. If you also specify that 28,000, we are out of it. This is the simple calculation, your losses. Paragraph 3, I says we are not parties to the proceedings before the learned single judge. Paragraph 4, my lord, none of the respondent writ petitioner belong to the para-teacher category. None of them. So our case was never represented before the learned single judge either. Then your losses kindly consider present appeal was taken out by us by application for leave to appeal, and that leave to appeal application was allowed by order dated 18th May 2023. Now I can take your losses to our first ground of the memorandum of appeal. I just read out because it's very difficult to find out the memorandum of appeal. That just now you lordship pointed out that I have not mentioned, we have not mentioned when the appeal was preferred that we should have been kept out of the panel, out of the judgment. That's I just read out the very first ground, that the learned single judge has failed to consider and appreciate that the appellants being all para-teachers were appointed in the post of assistant teacher in primary schools in the recruitment process of 2016 against 10% earmarked vacancies for para-teachers, and consequently they ought to have been kept outside the controversy raised in the writ petition, and their appointment ought not to have been cancelled.
And you did not refer to the observation made in para 22.
21.
22 of the judgment. Kindly come to that.
22 of the judgment, just your loss.
12th of May.
12th. 22. Huh? Page number, just a minute, I'm getting page number 22 Barca. Judgment. The board shall immediately arrange for a recruitment exercise for the candidates who were untrained at the time of recruitment, including candidates who have obtained training qualification in the meantime, within a period of 3 months from the date, only for
just read slowly. Only for the
the candidates who participated.
2000 up to here it is all right. Where those who participated, where both interview and aptitude test of all examinees shall be taken and videographed. So those who participated in 2016 process, where both interview and aptitude test. So this means that the fresh selection which you are going to conduct, according to the learned single judge, you have to take interview and aptitude. If
therefore I am excluded. That's your logic.
Where from you are coming?
Then your loss is kindly just before that.
Yes.
In such circumstances, I allow the writ petition, the appointment of all 36,000. Now this is 32,000.
No, that is separate.
Candidates who were untrained. Kindly see, I was also untrained.
All right. Next.
Then your
yeah, all right, finished. We understood your argument.
And then just two things your losses to be. That your losses, paragraph 7. Facts as well as law so far as the selection and appointment of the appellants as para-teachers are concerned are entirely different from the selection.
So you yourself, you are taking that ground now. You are saying that you cannot equate me with them. Terms of selection is different for
selection because your lordship, there was no aptitude test. That's unclarified. That there was no aptitude test for me.
There was no requirement for aptitude test for
That's why your lordship.
That's why. This is your argument.
This is my argument.
Thank you. Yes, who is the next senior in line, please? Mr. Ashok Banerjee is there.
One line in clarification. Neither Mr. Mitro nor Mr. Shanal represents para-teachers. They represent assistant teachers in primary schools or primary teachers who had a para-teacher background.
Why background you are saying?
That is the background. By holding the post of para-teacher elsewhere for a long period, they had been suffering. Therefore, the government considered it necessary.
They have been
suffering because they had no fixed scale, etc.
No, we are not concerned with that.
I'm not. Kindly, just I finish the sentence. They were suffering. Therefore, this reservation is made for them to apply for assistant teacher post in primary schools, and upon such appointment, they become primary teachers like all others. Their present status is a primary teachers. They have lost their para-teacher status. They had been para-teachers. Historically, yes. But today, they are all primary teachers.
So when they applied,
As para teachers, they were para teachers. They applied as para teachers, appointed as regular teachers. They are primary teachers, having a para teacher historical background. They are no longer donning the robe of para teachers.
so
They are-
then,
they are regular
then what meaning does paragraph 22 carry? That you have to hold interview and aptitude for all
Absolutely
the
yes. But
persons.
then, my lord, then the question is,
That
if
is
the-
your argument, but
no,
Mr.
that the previous, not the argument. Kindly see the judgment. The judgment, my lord, your lordships are trying to clarify, my lord, that if possible, they have to be harmoniously read, 21, 22. But the judge, my lord, that didn't have it in mind at all. It is absolutely clear from these two paragraphs.
তুমি তো একটা তো জোজকে বলবি ইউ রেকর্ড মাই আই ডু নট সে চুপ রাখো সরি
You know, this non-requirement of aptitude test for this group, that unless that is clarified, the board will be compelled to take, my lord, again.
Did not clarify. Nobody clarified. It was incumbent upon you to say this.
Your lordships, I didn't appear.
Mr. Gupta, is it for us to take that you were just lip tight? You could not say one single thing to the judge.
My lord, I will not use the expression, but that was the position.
That is your defense now. That I was not allowed to say anything. Where in your affidavit you have said that you are proceeding on a wrong basis. Show us one paragraph.
Where was this question? How did this question come up?
50 times matter was heard.
But how this question was never cropped up?
That is your argument now.
No,
that is not in your appeal.
Find out from the judgment.
Then you should have go back to the trial court and said you have
kindly find out from the judgment whether any consideration was given to this aspect, or whether nothing was stated in the petition on this.
Now that nobody will speak out and say, you will not tell me that your lordship is not proceeding on that basis. That your there, even if there is a scam.
Provided, my lord, there was a scope for that.
Achha, yes, next, Mr. Banerjee.
Para will come later on. Full now.
So you have anything to add for para teacher?
Yes.
So can you tell us, Mr. Mojumdar, which is your appeal?
This is item 74.
Just Mr.
Other matters.
Yes, we'll hear. Just we are taking Mojum. You are you are appearing for para teachers in para teacher appeal is which one?
74.
Mat number.
Mat number 913 of 2023.
Yes, Mr. Banerjee.
No, my lord.
Item number 41. It's a heterogeneous group of appellants. Some of the appellants in item number 41 are also para. This is I just
you please point
numbers in Milord's code.
No, we shall take down the note. It is very difficult now. We are handling so any other appeal where para teachers are part. Any of your friends
appeal? Of one only, that is item number 41.
You are appearing in that?
Yes. And 74 also, but I am assisting Mr. Mojumdar.
That Mr. Mojumdar's matter MAT 913 is item number?
74.
Item number 74. And Mr. Banerjee, you are for which one is
item number 41 today?
Mat number?
It's 1368 of 2023. which includes some of the.
Which is primary teacher plus para teacher.
Yes, say heterogeneous group of.
Yes, Mr.
Should I start, my lord?
Yes, yes.
So my mat number 1462.
Yeah, just.
Yes.
Mat number
1462 of 2023. Item number 49. 49, yes.
এইটা না yes লিখে নিয়েছো তো ওগুলো সব বের করে yes
Also need not take the trouble to open the papers because I'll very precise. I know the court is tired for the last few days going on. So I don't like to put your lordship in further whirlpool by repeating the entire fact once again.
no,
My
we
lord,
know that you will not repeat, we know that.
I'm grateful, deeply obliged. He has the number of petitioner 237. 237. For obvious reason, I'm saying because I am not the spokesman of everyone. I'm really concerned about my own headache, own problem. 237. Only 237.
So MAT 1462 has been filed by 237
237.
persons. You are
And they never approach the Supreme Court. They, after passing of that order, but they are not implicit the party. I'll come to that, my lord. We approach the honorable court with a leave to prefer an appeal. That was granted. Yes, that was granted. Yes.
Leave to appeal granted by which other?
September 4, 2023. These are all admitted positions. There's no problem.
Mr. Rasul Vishwas, this 44 appeals na 44
appeal.
Please tell us apart the board preferred leave to appeal, board preferred substantial appeal. And please, can you give the numbers of those MATs where they filed leave to appeal?
All other than board, all leave to appeal.
Oh, all leave to
appeal because none of them were party to the.
So all the leave to appeals were allowed. Then Justice Talukdar said that one part of the order is stayed, other part will continue. Against that, who went up in appeal? Board went up in appeal to Supreme.
Along with 2-3
along with Mr. Bandopadhyay's client.
Bandopadhyay's client, Mr. Joydeep Kaur's client, and my lord, are one or two.
Please assist us. If you can give a chart, it becomes easy.
I will. Next day, my lord, I will hand.
Chart master.
Yes, what did you say?
No, not for court.
No, what did you say?
Sometimes court says something we could not hear. So here also say.
We will also say about it.
Always.
So my first point will be, my lord, as we know, the persons who is coming to the court or rather knocking the door of the temple of justice, he must come not only with a clean hand, but with a clean mind. What is the legal right? I could have understood, my lord, that well. It is stated, I was not aware. There's a publications. It was not published in that way that everybody should know. They are participated in the selections. They're all candidates. They participated. They then face everything. They pass through that particular process. When they found, I have lost. After 5 years, they woke up with a slumber. Very cleverly, my lord, the writ petition is prepared. In paragraph 18, if I'm not wrong, he says it's a public interest. Public interest. As my lord knows.
Paragraph 15 of the writ petition.
18, if I'm not wrong. Public. If I'm not wrong, I'll correct it, my lord. No problem. Kindly trouble to that, my lord. Either 15 or 18. To my knowledge, paragraph 18.
No, It did not say public interest litigation.
Type of public interest litigation term is used for obvious reasons.
Term not used.
I've seen it, my lord, somewhere.
For
Paragraph 18. এটা কার্ডটা দিয়েছিস এটা? But it is there, my lord. I can assure you, my lord, I've seen. Kindly see. There is no delay in public interest litigations. Very interesting. Very significant. Why that was done?
Where did you get public interest litigation? Yes or no?
Page paragraph কত? Paragraph 18. Last. There is no delay. It starts with that. Have you got it, my lord? 5 years is no factor. There is no delay. There is no delay. And in filing the public interest litigation, as the corruption is still continuing and now single bench such and such. It's very funny. If it is a public interest litigations, the single judge cannot entertain the matter. And person having some interest in the lease of the litigations, he cannot approach.
Yes.
So, my lord, he has got no locus standi to challenge. If he either or, if he says these are public litigations, he cannot challenge. If it is a public litigation, single bench cannot hear the matter. So it is his statement. And if I am not wrong, it is due to my knowledge. Thank you very much. So this is really shocking, unfortunately. First, the enormous delay. Yes, as I've seen in so many cases, Supreme Court says, it doesn't matter. If I find there is some substance, we can interfere. But right from the beginning, he never approached the court with a clear mind, not only clear mind. It's equitable relief, there's a doubt about it. So this approach is totally illegal. And being failed, he just approached. Supreme Court has condemned that. I'll not take much time. I'll not disturb your lordship. My lord already tired. Argument, factual aspect. And I'll not enter into the factor because I was not a party there. Why should I? Kindly see one judgment. My lord knows it. 2017 9 Supreme Court cases. I'll hand over all those judgments compiled and a 5 paragraphs note. 2017, though I'll file in compile. আমার গলা শুনতে পাচ্ছিস না, it is my discredit.
79 Supreme Court.
I remember in one case, I was arguing in Kundu number 18. You were Justice Mukulwar Mukherjee, Justice if candidate, paragraph 4 to 12, I'm just spreading the white notes, which is normally going to do, but if candidates participate in selection process, have you got it, my lord? It cannot subsequently turn around and question selection process or constitution of selection committee only because he was not selected. On fact, else, High Court erred in ignoring well-settled principle of law while rejecting objections to maintain the writ petitions. So after being failed, he participated in that. I could understood that, well, he has got no interest, but for the greater interest of the state and the public, he approached in the public interest litigations. That means if anything mischief is done, it will continue. No, any other person come and say, here is the wrong, please correct it. But he is not, they are not permitted to approach. Because suppose if they are selected, they will accept everything. Oh, everything is all right. Because they could not succeed, they jump up after 5 years, they woke up on the slumber and they came with an unclean hand. And Very unfortunate. They challenge the selection process. Good but indifferent. I'm not entering into the merit. So this is my first point, my lord. He has no legal right. That's a vital aspect.
Thank you.
Certainly, my lord can ask Mr. Manager, we are here. We are hearing you. You enter the merit. No. Supreme Court says, if it is found that, well, person against whom the order is passed, he is not made a party, order should be set aside. Very short judgment, very well compact. That is reported in. I assure lordships, my lord, I will not take much time. Only question of law. I really like this judgment for obvious reasons. I'm being half a minute time.
When you are on the other side, you will not like the judgment.
My lord. We don't mean. Just a minute. আচ্ছা কপি আছে পেপার কভার বার কর না না ওটা দিলে এখন ওটা ফলো করে দেখতে পারে একবার That's very interesting judgment, very short judgment, one pack. I've seen only two honorable judges of the Supreme Court. They delivered this one, Justice G. and Nazir also then was, and this one. Kindly take trouble to come at page. The gallery, bundle to chill. I'm being happy this time. No, আচ্ছা পেজে তো জাজমেন্টটা কোথায় গেল এর মধ্যে বুঝিস নি
Yes.
Yes. Kindly take trouble. There are reported 1996 3 Supreme Court cases. I'll hand over the judgment.
1996.
1996 3 Supreme Court cases 587.
Paragraph.
There's one paragraph, very interesting, very short judgment. I'm reading. Why I'm referring, I'll come. Leave granted. We have heard the learned counsel of the both rights. It appears that the appointment of the first respondent was annulled by the proceeding that is such and such. Consequently, see such and such, learned counsel for the first respondent states that his client has lost interest. Very cleverly, I see. My lord, not cleverly in the morning. I wanted to withdraw for other reasons. But here, not that cleverly. Honestly, I must actually confess. But here, he's a very cleverly.
So, unless you were caught on the wrong foot, you wouldn't have done it. And Mr. Banerjee is there. He will not leave you.
Since a phrase cause of action has arisen, he is not contesting the matter. It is not in dispute, which is very interesting, that the appellant was not a party to the impugned order dated 15 June 1993, made on way number such by the Tamil Nadu Administrative Tribunal Madras, without being implicated as a party. Appointment of Thomas was annulled by the impugned order. The tribunal, therefore, has committed grave error of law in upsetting his appointment when when he was not made a party. The impugned order is set aside as regards the appellant. As regards the appellant. So that's why I'm not taking any risks or anything to enter the merit. Why should I? Supreme Court says, since you have not been able to the party, and here you only apply in case of 253 petitioners. I'm not speaking for the others.
1996. 3 years.
I'll give the judgment. Supreme Court could have said, all right, I'm setting aside, I go back, we are directing the authority to consider once again. Supreme Court said, no. It is set aside. It can't stand in the eye of law. So that's why what I'm on. Since we have not been implicated as a party, and no opportunity is given, which is a fundamental principle, the order was passed, and I've lost my job. What's wrong I've committed? I'm asking myself. Is it found by the court that, well, I'm a bad man, I've adopted wrong practice, illegal practice? I could have understood. No adjudication is me. Even my district Nobody called for to test. Nobody was examined. Malda, I am from Malda, so totally.
All of you are from one district. All your petitioners are from one district.
Yes, Malda. Yes, Malda. Malda was never called for. No person was invited. All I want to examine. I cannot say court cannot do that. But under what circumstances, I will not answer. I will not enter the merit.
Thank you, Mr.
So, my lord, what I am on, my lord? Law doesn't mean to be mere theoretical abstraction. It is an instrument to do justice. Is it justice which what I have got? Is it really a justice? What wrong I have committed? I am repeating else again. Now, my lord, another thing is this, my lord. Peculiar, my lord. Because it is not a public interest litigations, court has got its own restrictions. Because on the basis of postcard, my lord, even Justice Bhagavati entertained no problem. When my lord is seated in the public litigation bench, when I say, no, Mr. Banerjee, I've got the information. That is enough. After it is the public interest litigations. You are here to protect the interest of the public as a whole and the interest of the state also. This is not a public litigations. So whatever we have said as a petitioner, court certainly will restrict himself within that. There is a Supreme Court judgment, my lord, to that effect.
On the ground of?
Court cannot travel beyond that pleadings. Because what is the distinction between? Yes, I'll give you the reference, my lord.
It has been argued, Mr. Banerjee. You are...
Yes, if it is argued, it's all right. No, but why this judgment, particular judgment was cited or not, I do not know. Well, that is reported in, if it is cited, I do not know, 2003-8 Supreme Court cases. Page 40.
40.
40. If it is cited earlier, that's a different thing.
In the absence of pleadings, you cannot argue. That is the...
That's a very, why? Justice Murani, another judgment I cite, my lord, made a very beautiful distinction between the plaint and the writ petitions. Now, let me just finish it, my lord. Article 23, practice and procedure. Issue in question only to be considered. Disposal of the case on a point not raised by the parties and omission to decide the question raised held improper. So if I raise something, but it is not adjudicated, that is improper. If I do not raise, but court took the responsibility to decide this things, that is also improper. Here also, my lord, from the writ petition, absolutely vague. I am sure it is not drafted either Mr. Bhattacharya or some junior chile, they thought this is enough. They took a chance. After 5 years, all right, let us take a chance. Now they are trying to build something without having any foundations. This is really unfortunate. Why you have said it, my dear friend? Why court will take the burden? Today I cannot bring so many things and put it on your shoulder. Kindly, it's like sometimes in the lower court it is even, apni to sir janen, ei judgment dekhe neven. Are bhai, how is it? It's all burden on the court. So this is the case, my lord, where I'll hand over the judgment, my lord. That will it is improper. It should not be encouraged. Now, my lord, this is another judgment. My lord, to say something.
Yes.
Asking me something, my lord. No. Which is reported in 1988 4 Supreme Court cases 534. 88.
84?
88.
88 Supreme Court cases.
88 4 Supreme Court cases. 534.
Like 534.
Yes, my lord.
On the proposition.
I'm reading, my lord. As has been already noticed, although the point as to profiteering by the state was pleaded in the writ petitions before High Court as an abstract point of law, there is no reference to any material in support thereof. Even by saying some question of law will not do, there is a basic and fundamental difference between the plaint and the writ petition. Because plaint only mere fact. then there is scope for now affidavit chief to be filed along with the print. Then written statement, disclosure of documents, evidence, all those things. But the writ petitions, what I moved, my lord, I must annex all the relevant document, point of law based on the question of fact. Point of law. There was no reference to any material in support thereof, nor was the point argued at the hearing of the writ petitions. Before us also, no particular and no facts have been given in the special writ petitions or in the writ petition or in any affidavit. But the point has been sought to be substantiated at the time of hearing by referring to certain fact stated in the such. In our opinion, when a point which is ostensibly a point of law is required to be substantiated by fact, the party raising the point, if he is the writ petitioner, must plead the proof such facts by evidence which must appear from the writ petition, and if he is the respondent, from the counter affidavit. If the facts are not pleaded, or the evidence in support of such facts is not annexed to the writ petitions or to the counter affidavit, as the case may be, the court will not entertain the point. In this context, it will not be out of place to point out there is a distinction between the pleadings under Code of Civil Procedure and a writ petition or a counter affidavit. While in the pleadings, that is a plaint or written statement, the facts and not evidence are required to be pleaded in a writ petitions or in the counter affidavit. Not only the fact, but also the evidence in proof of such fact have to be pleaded and annexed to it. So the point that has been raised before us by the appellant is not entertainable. So, my lord, why that was done? For various reasons. Because it is the original code, my lord. And process is only process.
Mr. Banerjee, this was argued.
My lord?
This was argued, Mr.
Very well. If it's argued, I need not propose it. I was not there at that time. So,
thank you, Mr. Ganguly. Mr. Banerjee, thank you. Yes.
Now, last but not least. Kindly appreciate one aspect. When there is serious civil consequences, court must be very serious and cautious. Today, my lord, after working for 5 years, it's very unfortunate when one of my client, he returned to his home. Tiny daughter just asked, Baba, tomorrow arju chuti? Tomorrow ki rojo chuti? My client couldn't answer. What wrong I have committed that I have been punished in this way? Article 21 totally violated. That's why I started. Law doesn't mean to be mere theoretical abstraction. It is an instrument to do justice and justice for all. Even a person commit a murder, he is also getting the opportunity. And I am not getting an opportunity.
Why you are before us?
No, my lord. That's why
getting an opportunity.
No, that's why I cited the Supreme Court judgment. I did not enter into the merit. I said, no, why should I lose one forum? If my application or contestant is rejected, then I'll go. He can welcome. Lordship need not bother. I'll come and disturb your lordship. My lord, I need protections.
Thank you, Mr. Banerjee. Yes. Next.
35. Item 34, MAT.
Well, I'll repress.
1109. 1109 of 2023. Mike Lagla.
MAT 1109
of 2023.
1109 of
2023.
Item number
34.
No para teacher involved. Yes.
Absolutely different category which has not been argued by anybody up till now. I've got the information. We are the exempted category candidates. Most of us are land loser category and other freedom fighter category with that. One or two. Mainly land loser category.
Certificate, we have to submit the certificate.
How many persons you are there?
In this matter, 39. They are from the districts of Malda and Murshidabad.
Yes.
We are provided with a certificate that our land was taken, and by depositing that certificate, we obtained the job. But I will submit before my lord the entire process which is alleged to be, my lord, violating of rules, norms, scam. Either way, I am not affected. Why I am saying this? Exempted category posts are earmarked. Vacancies are earmarked. And the candidate who's applied under the vacancy is much more less than the this published vacancy.
Pardon? Candidate
who applied for under this category are much more less than the total vacancy declared for to be filled up.
Yes, because all were not filled up.
No. There, my lord, whether I was completing this aptitude test or not has no relevance at all. Because there is a marks prescribed. If I am getting 0 in aptitude test, I should be selected. Because the other part, which, my lord, is the requirement to be appointed, I am completing.
So did you get 0?
No, there is no aptitude test. This is allegation.
In respect of you, there was no aptitude test.
That is the allegation. Because we are not party in the code below. There is an allegation.
You are meaning to say that even if aptitude test was not taken, we would have got appointment on the basis of the other marks, since the number of vacancies was much
available. And second ground is that you are not trained. Your lordship has already argued that that category, after appointment within 2 years, I should pass through that. I have done that. Within the time limit which relaxation was there in the rules, I have completed that. আমার অ্যাপ্লিকেশনটা খুঁজে দেবে একটু অ্যাপ্লিকেশন দিতে হবে স্যারকে can 34 2
MAT 1109.
I'll only show you the 2 documents. Probably this point was never up till now not arts before my.
No, your argument is even if you are not given aptitude test marks, then also on the basis of the marks obtained by you
other categories, there are so many categories of giving marks, including aptitude test. Even if aptitude test is not there, even if aptitude test I am getting 0.
Then how do you think you will come within?
Yes, because of the exempted category.
You are in Malda and Murshidabad. How many vacancies?
Yes, well, that's want to show to lordship. Can I take my application? This is available to my. I asked.
No, any paper book file your case?
No. Here, my application is there.
So, paid for item 341109.
I requested my lord officer to get a can 2 of 1109.
No, what you want to show us that?
I want to show to lordship what are the vacancies declared. Declared vacancy
in Malda.
Malda and Murshidabad.
So tell us.
Yes, my lord, Malda and Murshidabad. Total vacancies are, so far as Malda is concerned, 161. Just a minute. Is it for legal? Yes. Now, my lord, so far as Murshidabad is concerned, there are altogether 761 vacancies, 762 vacancies. Declare vacancies to be filled up.
Murshidabad, how many vacancies?
761.
Yes.
Out of that, only 121 candidates were appointed.
They were trained or untrained?
Untrained in view of the circular,
this 121.
Untrained, but after the appointment, within 2 years, they complete the training.
So, in 761 vacancies, no trained candidate was there?
No.
How do you know that? How have you come to know that?
So far as 39 is, we are there. We are not trained. I must be candid before my lord. But we have completed the training in terms of the circular within 2 years from the appointment.
No, your argument is the vacancies were, so many vacancies were there, irrespective of marks in aptitude, I would have got appointed.
What is the test, my lord? Kindly.
That becomes a very.
No, I am showing to lordship. Can you take my copy? Your lordship will find this.
No, tell us now what you are wanting to show.
This is, my lord,
761 vacancies.
Yes, there is no cut-off marks. Marks are like this: Madhyamik pass 5 marks, higher secondary pass 10 marks. Training as prescribed sub rule 6 to 15 marks. Teacher eligibility test 5 marks. Extraordinary extracurricular activities 5 marks. Viva voce or interview 5 marks. Aptitude test 5 marks. Total my lord 50 marks. There is no cut-off marks. Cut-off marks means pass mark. Nothing is there.
Yes, that is all right, because you are saying if you aptitude test, even if I got 0.
My lord, what will happen if there is an aptitude test and total number is given? Then my lord, if there is suppose 7,200 vacancies, 1,000 is eligible candidate. Then my lord, for considering those, a cut-off mark has to be given. The eligibility test, if given a better mark, you will appointed. But so far we are concerned, vacancy is still lying. Even assuming there is a scam, we are not on that zone at all.
The argument for it.
We had to.
All right.
But so far as this candidates are concerned, in the exempted category candidates, landlords and freedom fighters.
All right. Any new issue, Mr. Basu?
No, if Lordship wants, the application is my lord. Kindly come to page 48. No.
Which
can two.
Page 48.
48. Can you see? Or this is my lord appointment notification. It starts at page 47. Kindly come to 48. Note 1. The persons qualified state and having qualification of higher secondary under the Honorable Council Higher Secondary Education, it is equivalent with at least 50% marks on graduate with 2-year diploma, whether name known in accordance with the National Council for Teacher Education. Also be eligible to apply for appointment of primary school teachers in the state, subject to condition that those who will be appointed without professional qualification, we are coming under that, shall acquire the professional qualification within the period of 2 years from the year of appointment. We have concluded that. Today, my lord, after 2 years, within 2 years, we have concluded that. Now, my lord, kindly come to the 5. Procedure for selection.
Yes.
The procedure, my lord, aptitude test is there.
Yes.
But my submission will, if you also turn out, you also will get the marks to be given. And while giving these marks, there is no past mark, year marked. So if I am completing, my lord, this qualification, minimum qualification, and if there is vacancies available, my lord, there is no need to have any, my lord, in unfair means. No necessity of giving any backdoor system, because I am on the basis of my qualification, I should be appointed.
Yes.
Well, at the single judge বলেছিল কি বলতো এটা এটা জজের অর্ডার
ইন্টারভিউ হবে আর অ্যাপটিটিউড টেস্ট হবে তো আমরা
in the appeal, paragraph 22 of the Honorable Single Judge's order. Any my lord, which my lord has marked that any order your lordship can take.
Para
22.
Last but one, please.
The operating portion of the order. Justice Mr. Kali got it. The board shall immediately arrange shall immediately arrange for a recruitment exercise for candidates who are untrained at the time of recruitment. Now you are trained within a period of 3 months from the date only for the candidates who participated in 2016 recruitment process, where both interview and aptitude test to all examiners shall be taken and the whole interview process has to be videographed. Is not necessary. But if today this is done, what extra I can gain, with extra I can lose. If today there is interview, suppose again aptitude test, I am there, even if I fail today.
Yes.
Then according to my humble summary, this is a futile exercise where this categories, exempted categories, persons are concerned.
Thank you, Vishwas.
That's all.
Rajesh Kapita. No. Like witnessing a marathon.
You are in which
and also, my lord, I would be referring everything from the paper book so that no different paper. I am appearing item 36, MAT 1322 of 23. Some of us
1322. And
some of us were before the Honorable Supreme Court, and
you are only for BAT 1322.
yes, there are 635 candidates who were working. Our appeal leave that all were allowed by order dated 12th of September 23.
Appeal
12th of September 23, by an order, the Honorable Coordinate Division Bench stayed so far as the termination and other portions are concerned post Supreme Court.
12th of September.
September 23.
Yes.
Now, I made a note. Most likely none of the points that I am going to repeat. My first, if I can, my lord, formulate, my first point shall be our 25 judgment of Justice Gawai versus, my lord, the present situation and the learned single judge. Before placing this, if I can just, my lord, place the relevant portion and thereafter I make my submission. My lord, 2025, there is a judgment where is a Kaushik Das judgment. 3 fundamental things have been held by the Honorable Supreme Court. Number 1, there can be a just and untrained persons like the writ petitioners. Now, I would explain what do I mean by the word just. Number 2, there are untrained who fulfilled 3 conditions as clearly said by the Honorable Supreme Court.
But this was in relation to that NIOS selection.
Yes, exactly.
2025
It is related. It is related.
How
It is directly related. I'm coming.
How?
By virtue of the Honorable Supreme Court judgment, once
there was no allegation of
may
scam
I
in
come?
that selection.
Yes.
NIOS, no allegation of scam.
I am not on that. I'm not on that. I am a completely different thing. Let me say metaphorically, thereafter I will say. My situation is, let me use the word that all of us, we were untrained, correct, at the time of recruitment. So let me term myself as we were caterpillars at a particular time. But by April 2019, having fulfilled 3 conditions based on the judgment of the Supreme Court, after setting aside Calcutta High Court single bench and the division bench, I have become butterfly from April 2019. I had my
Supreme Court order. High Court and Calcutta High Court ordered which order?
The Calcutta High Court single bench declared that because you are untrained, just the way the learned single judge has held that because you are untrained, therefore you are not at par with the trained. You are different. That's the basis of the present judgment. Can you look at the learned single judge's
That
judgment?
is because the persons who approached were all untrained.
May I say this?
Their case was we are untrained. Our colleagues who are also untrained
Yes.
had been favoritism. There was favoritism.
But that is the different thing. I'm saying, my lord.
Why you are taking us to any other?
No, I'm saying something different. Can you visualize this?
You are then diverting from the
I'm not diverting. Well,
Then
once
why you are citing these judgments?
I'm citing this judgment because of the reason that after April 2019, writ petition was filed in 2022. I could have understood the writ petitions having filed before 19. Okay. After 19, once the Honorable Supreme Court declares that untrained are at par, the entire basis of the learned single bench of a distinction between untrained and trained.
That was not argued.
I'm arguing. I was not there. So
You are.
I mean, we were not there.
At the instance of making an argument,
Yes.
you divert from the issue and take another Supreme Court judgment of 25. His Lordship did not take into consideration 25 judgment.
But Lordship cannot deny that the Justice Gawai's judgment cannot be nullified. Justice Gawai has held three things.
Mr. Dhar,
yes,
please kindly come to the terms of the judgment.
Yes.
Take us to other
Correct.
new judgments which have come. My lord, this cannot happen.
Let-
Don't take us to all those.
I'm coming to the judgment. Directly three paragraphs. After that, if your Lordship feel that it is not relevant, I will not place it. Kindly take paragraph. That you have to.
Is this pertaining to the 2020 this recruitment rule?
It is pertaining to each and everyone who was untrained, but who was.
Is this pertaining to recruitment rules of 2016, which we are saying here? It has anything to do with the 2016 recruitment?
Yes,
rules?
it does.
Has it been referred to
Kindly
2016?
kindly read 26 paragraph.
Mr. Dhar, just the appeal has been sent that everybody will.
No. I'm not.
In his own.
This
matter.
is one of the, according to me, one of the most fundamental points that destroys the very basis of the learned single judges.
Jayantuni Pro, learned advocate, appearing for the appellant them, we will request them to make an
No, my
endeavor
lord,
to
Mr. Samim will not get turned, my lord, subject to your lordship's kind consideration, my lord. He is, my lord, addition of party, my lord. That is subject to, my lord, my lord.
Mr. বিশ্বাস, why you are taking?
But
We
he is
want
the
to
lead
know the
petitioner.
version of the read petitioners. Why you are
He
not
is the lead
understanding?
petitioner, my lord.
So where they are at par with the read petitioners. Who is your leading counsel, Mr.
Mr. Bhattacharya, Vikas Ranjan Bhattacharya, my lord. This is a day after 10 any days.
We have kept it on 14th. We would be requesting my other friends to conclude it by 3 o'clock. We will sit at 2 p.m. and take that. And so that Mr. Bhatt, because we are not being able to understand your stand, your specific issues, so that we can question them. We have substantively heard. Now, unless opposition, what is your
Contention.
contention? Apart from
What is
the
the matter
evidence,
about all about
so that you please, unless you tell it to us, we won't be able to take this clarifications. So please ask, we have recorded that on the next date, the read petitioners would be ready to make.
Lordship, may kindly, but well, only one thing. I know that I have just begun, so I will take some time. I will not be repeating anything, and I will be as quickly as possible. That Lordship can take my words.
One can go on for
No, I will not like to go on, my lord.
Maximum we can request.
I would
now, if you insist.
My lordships are not required to make any request. We take that in our responsibility.
Sir, we will ask you. Suppose you are arguing a thing, let us get the response.
Allow me to complete. Thereafter, it will be better. For an example, my lord, there are a couple of.
It has been substantively argued.
Now
This teacher has been substantively
right.
You are insisting on us to go through another judgment which has been delivered only a month ago.
Well, yes, madam,
Now you will be making out a new case.
Madam, which can save us. If something can save us, my lord, if that is allowed.
If something can save you, let us appreciate what they are content.
Well, I don't have any difficulty. I say not in the midst. I have started my argument. Kindly allow me to complete my argument. Thereafter, whatever questions lordship have or whatever they have got.
Yes, we will allow you. We are not saying we won't be allowed.
Deeply obliged. This much.
What more can we say? We can only request you people that please curtail your argument.
We have had a talk among ourselves so that we are not repeating.
I will, by the clock, I will conclude within 30 minutes.
Please ask Mr. Bhattacharya, he used to be the leading argument on your part. So if we can.
Mr. Mojumdar, Soma Mojumdar.
Very good.
They are not appearing for the petitioner, the petitioner, subject to correction.
Whoever is it, let their version come now. Let their version come. Let us.
Physical handicap teachers, their case has not been heard, my lord. Will that be heard? Physical handicap, they are separate category, my lord.
Your lordship granted leave to file these compilation, my lord. I am filing.
Give it to us on the next day.